Thanks to everyone for your patience. It usually works, but sometimes glitches happen in cyberspace. I will call to order the July 23rd, 2020 meeting of the Public Disclosure Commission. The time is 9:39 a.m. and we are again meeting remotely by teleconference in accordance with the governor's emergency proclamation 20-28 as amended. The governor's order says that the public's ability to attend is by remote and that in-person attendance is not possible during this time. The meeting is being live streamed and recorded as well. Our published agenda did provide a call-in number for public comment at the top of the meeting, and we will shortly begin doing that. My name is David Ammons. I am chair of the commission, and I'm pleased to be joined by the 4 other commissioners from around the state. I would invite them to introduce themselves at this time.
Fred Jarrett, Mercer Island.
This is Bill Downing in Seattle.
Russ Lehman in Olympia.
Sorry, Nancy Isserlis from Spokane. Sorry to hang the meeting up earlier.
No problem at all. We do have staff and council and others also who will be working with the commission throughout the agenda. And I would appreciate any who are currently online with us right now to identify themselves, starting with our esteemed executive director.
Peter, you're on mute.
You're muted.
We can't hear you.
I know you can't. Thank you. No.
I take back the esteemed part.
Fair enough. No, I was chastising you for going off script. We even had a list of how we were going to introduce ourselves this time, and it started with the AAGs. But so you're forcing us to improvise instead.
Oh, flexibility, man.
Yes, we're happy to do it. Peter LaValle, executive director.
BG Sandal, deputy director.
Kim Bradford, communications and outreach.
Sean Flynn, general counsel.
Janet Greer, administrative officer.
Hi, this is John Meter.
Go ahead, John.
I'm sorry, John. This is John Meter, Assistant Attorney General for the Commission.
And Chad Stanford, Assistant Attorney General for Commission staff.
Thank you very much. I appreciate that. We, at this time, will be opening public comment, and I would note for those who are interested in commenting on the professional staff F1s. First of all, I wanted to note that we have heard from the House professional staff members several times in the past and have taken note of their concerns, and also I have not heard from the Senate side, but just wanted to note that, and we are in possession of any written materials that were submitted. I would further like to stipulate that the commission concurs that you are doing this on your own time, so you don't need to include that in your remarks. And finally, I would like to ask that that you keep your comments to about 2 minutes. If you could do that, we would appreciate it. We have quite a few people that would like to testify. So Jana,
Yeah.
who is at the top of the queue?
We had a Mr. Is it Easkins? And he has not joined us yet. So at this time, we're going to go to, I'll tell you the order. Number 2 will be Jim Morishima. Number 3 will be Kelly Leonard. 4 will be Jill, is it Remuth? So if you could just go in order of 2, 3, 4, and number 5 will be Kurt Gavigan. So go through 2 through 5.
Very good. I would invite Jim, number 2, to take the floor at this time.
Thank you very much. Good morning. For the record, my name is Jim Morishima. I'm the Assistant Director of the House of Representatives Office of Program Research, the nonpartisan committee staff. I'm sure you're familiar with me. This is the 4th time that I've come before you. And like the previous 3 times, I've taken personal leave to talk to you on my own behalf. I know you told me not to reiterate that, but it's important to me because we are prohibited by House rule from lobbying on state time. So I wanted to make sure that I had that on the record. Dating back to 2018, you've heard from many of my colleagues regarding concerns they have about the misuse of the information on the F1. You've heard from people worried about harassment, military spouses worried about their loved one's safety, and people worried about identity theft. In your last meeting, in fact, I spoke to you about the uniqueness of some of the data on the form and the potential for its abuse. I was therefore surprised and dismayed to read a story by Austin Jenkins on the issue in which PDC members and staff indicated that they do not feel that the F1 is a unique data set and there is no evidence that the PDC has been targeted for security breach. So I just wanted to address those issues really quickly for you this morning. At the risk of repeating myself, I wanted to reiterate that the F1 is indeed a unique data set. Although it does contain some information that can be ascertained through other means, the F1 includes unique information that can't be found elsewhere, including banking information and even information on what type of vehicles filers own. While I'm no cybersecurity expert, I do not believe this information is publicly available anywhere else. Plus, the fact that the F1 aggregates a plethora of personal information in one place makes it a unique document, even if some of the information on the form is already public. By looking at the F1, a potential identity thief can tell approximately how much money a filer makes, where he or she lives, the name of his or her spouse, where he or she banks, what types of property he or she owns, and the identities of his or her creditors. I don't know of any publicly available document that includes all this information in one place. The second thing I wanted to address was the security breach issue. I think the assertion that there is no evidence of a security breach misses the point. The issue should not be whether there has been a security breach. Rather, the issue should be whether actively publishing personal information on state employees makes them more susceptible to harassment and identity theft. I do not think there is a cybersecurity expert in the world who would think it would be advisable for me to publish my banking information online, which is exactly what you would be doing by broadly publishing my F1. Furthermore, I am confused by the focus on security breaches. Why would a potential identity thief need to breach PDC security when the information they seek is already published on the web? For example, you don't need to break into a bank if it leaves all its cash on the sidewalk. I know that what I say here today may make no difference in what you ultimately decide to do with my personal information, but it's important to me that whatever decision you make be an informed one. If you choose to publish unredacted staff F1s online, what you will be choosing to do is publishing a wealth of sensitive personal information about public servants to the world, information that in some cases may be exempt from disclosure under the Public Records Act. I hope you are correct that this information will never be used for nefarious purposes, but in the unfortunate event that it is so used, I hope you will remember the testimony of all the dedicated public servants and their families who tried to sound the alarm. Thanks for your time this morning.
Thank you very much. Next, Jana, who is next in the queue?
Kelly Leonard is next.
Kelly,
Can you hear
have
me?
the floor. Yes, you have the floor.
Thank you. Good morning, commissioners. My name is Kelly Leonard. I'm currently employed as a nonpartisan attorney at the House of Representatives, and I'm speaking to you in my personal capacity today. And I've called to offer comments on the topic of publishing professional staff F1s on the internet. I've already provided comments at previous commission meetings expressing my concerns with internet publication of employee F1s, including highlighting the unique position of nonpartisan legislative employees required to file F1s and how we are especially vulnerable to harassment and retaliation. I hope you do consider those prior comments, and today I ask you to consider 2 additional points. First, I believe that the Commission has at least a moral obligation to think about the consequences of its decisions, meaning it should not just limit its analysis to legal liability, And second, I believe that publishing F1s and expressly shifting this issue to the legislative arena essentially excludes the most affected parties from the conversation going forward. Beginning with the first point, at the commission's last meeting, some commissioners and staff indicated that since F1s are public documents, there can be, by definition, no misuse of them. I know that we all know that this isn't actually true in a practical sense. This position at best is overly legalistic and simplistic. It might be so that the commission would not face legal liability as a result of misuse, but the information in these documents can be used to hurt people. The F1 filing process was not created to serve identity thieves, harassers, stalkers, or those who aim to retaliate against state employees. As one of your staff stated in the last meeting, F1s have historically been treated differently, and there is an acknowledgement that the wholesale publishing of certain classes of records might cause harm to individuals or even change agency operations in a way that is not in the taxpayer's interest. I assume that this is why the commission chose not to publish F1s for so many years. There was an understanding that these documents were different than other filings. From my perspective, nothing in the commission's public deliberation seems to indicate that there have been substantive changes to the documents to warrant the change in how the commission categorizes them or treats them. And I believe if releasing these documents worsens the working conditions of the legislature or causes harm to any person, I believe those costs outweigh the benefits of publication, especially where there appears to have been very little demand for accessing employee F1s at all. And more importantly, where the public interest associated with the F1 filing process can still be achieved through the Commission's long-standing practice of making the documents available upon request. As to the second point, the Commission and Commission staff have previously indicated that the concerns expressed by legislative employees are a problem to be addressed by the legislature. In fact, on multiple occasions, it has been indirectly and frankly directly suggested that if legislative employees don't like filing F1s, we should ask our bosses to change the law. First, nonpartisan legislative employees are legally, ethically, and professionally prohibited from influencing or lobbying for legislation. We cannot participate in that process in the way that some folks seem to think that we can. Second, this is not about the F1 filing requirement. I haven't heard any legislative employees appear before the commission and say that they should not be required to file F1s. I'm not asking for an exception to the F1 filing requirement, and I am pleading with you to maintain the commission's long-time practice of not publishing these documents on the internet. The commission has raised this issue on its own. It is a discretionary decision regarding an administrative practice. The law does not compel the commission to publish these documents. There is no apparent legislative issue here, and I hope that before the commission moves forward with publication, it will consider developing some other deliberative process where the concerns of legislative employees can be considered in more detail. If the commission cannot be persuaded by the many concerns expressed by public employees, I ask the commission to fully redact any personally identifiable information and financial information to the extent it may be permitted and possibly required by the Public Records Act. Please think about the many concerns brought to you by many employees these last few years. And I really do pride myself in being the type of person that doesn't make mountains out of molehills. My concerns are very sincere, and they are based on a decade of experience employed at the legislature. Thanks again for listening to me today and making public comment possible during these very unusual times.
Thank you very much for your comments, Kelly. Jana, who is next in the queue?
Jill, are you there?
I am.
Okay, go ahead.
You have the floor.
Good morning, Chair Ammons and Commissioners. For the record, my name is Jill Reinmuth. I am nonpartisan professional staff at the House of Representatives, and specifically, I'm the director of the Nonpartisan Office of Program Research, the committee staff. As you know, I'm here in my personal capacity as a private citizen who is a public servant, and to share my concerns about publishing F1 information for professional staff online. Mr. Morishima and Ms. Leonard have eloquently addressed some of the risks that are involved in this, whether it's identity theft, harassment, intimidation, and retaliation, or privacy protections. And I've spoken to you about those concerns previously. So today I want to focus a bit on concerns about the process that has brought us to this day. And quite frankly, one of our concerns is simply this: is our testimony just a waste of time? When we testified before you last month, some remarked that our testimony was not timely, that the commission was only considering the issue of posting F1 information for elected officials and not for professional staff. And so we are here again today. But now the timing is significantly different. It is less than 24 hours before our information will become broadly and readily accessible to anyone with an internet connection anywhere in the world. As we prepared to attend this meeting, some told us that your decision, as they say, a fait accompli, that the decision has already been made and that taking time to testify is merely a waste. I certainly hope that's not true. Perhaps the decision is a simple one, either post or don't, and the short time remaining isn't a problem. But if the decision is different than that, I'm concerned that the remaining hours do not afford the commission or interested parties the time to thoughtfully discuss alternatives that might adequately protect the privacy interests of non-elected professional legislative staff and the public interest in access to information about elected public officials. I'm also concerned about assertions of legislative inaction. Others have suggested the commission's perspective is this. Look, we gave the legislature 2 sessions to address this issue and they haven't. In other words, if the legislature objected to the commission's plan, the legislature could have passed a bill and told us not to go forward with it, and they didn't. But any assertion that the legislature hasn't taken action is false. As you know, in the long session in 2019, the legislature passed Substitute House Bill 1195, which included in Section 7 a provision prohibiting the commission from posting statements of financial affairs on any website. The governor, however, vetoed several sections, including Section 7. And it's my understanding that the reason he vetoed that section was that the commission asked that he do so. Not through any formal action, of course, but in the informal ways that agencies provide feedback on legislation on the governor's desk. And in the short session in 2020, the House passed Substitute House Bill 2772, which would have prohibited the commission from posting F1 information filed by a professional staff member on any website with a wide margin, nearly the widest, 97-1. The bill made it to the Senate floor calendar just days before the short session adjourned, at the time when everyone's attention was turning to COVID-19 and the global pandemic that was looming. Lastly, I'm concerned about gubernatorial direction and agency activity, just going back to 2019 and the governor's veto. In the veto message that year, the governor specifically recognized that the commissions had discretion in this matter, noting that the commission currently has the authority to decide whether or not to make F1 forms available online. He continued, saying that the commission has already embarked on a process to work closely with the legislature and other interested parties over the interim to consider the privacy interests implicated in certain types of information and the compelling public interest in access to financial data of public officials. And finally, he suggested that the proper balance between privacy and access could be different for staff than for candidates and elected officials, that public interest is different when he explicitly requested that the commission consider possible alternatives for non-elected professional legislative staff. Well, it is true that the commission staff conducted a broad survey of the regulated community over 2019. I am unaware of other specific outreach and opportunities for non-elected professional legislative staff to engage in more in-depth and thoughtful discussion, nor am I aware of alternatives that the commission might have considered. In closing, I continue to respectfully request that the commission weigh the public interest and the privacy concerns and not post F1 information for professional staff online, that it continue to be provided in response to specific public records requests instead. And alternatively, I would suggest pressing pause so that the commission can consider alternatives for non-elected professional legislative staff, as outlined in the governor's veto message. You've heard some of those ideas already today, and I would welcome the opportunity to talk with your staff and to talk with any of you individually, and would gladly take more leave to participate in those discussions. And I feel confident saying that other professional staff would too. Thank you for your time.
Thank you very much. Jen, are there any others in the queue?
There is, and before we do the last one that I have, I want to remind you that Mr. Easkins was going to participate and has not joined yet.
Okay.
And we'll have staff reach out, but at this time, he has not joined. You have one last person that signed up, which is Kurt Gavigan. But before we switch to Mr. Gavigan, when he's done, if you could note the 2 comments that came in via email afterwards, that would be great.
Thank you.
Go ahead, Mr. Gavigan.
Good morning, Commissioners.
Good morning.
My name's Kurt Gavigan. I have the privilege of serving as staff director for Senate Committee Services, which is the nonpartisan staff team for the Washington State Senate. I taking time off to participate this morning and really appreciate the opportunity to address you all. I'm used to being a staffer in meetings, so I do not regularly participate as a commenter. So it's a unique experience for me. Appreciate the chance to do that. I'm here to speak on the F1 issue. Similar perspective to my House colleagues, so will not repeat their comments. I'd like to touch base with you on 2 items. First, what I think today is opportunity you have to strike a win-win balance on this issue. And then 2, the opportunity that I think you have today to help avoid negatively impacting staff morale. So first, in terms of that opportunity to strike a win-win balance, so the longtime status quo has been to make F1 information for legislative staff available on request. I think you have the chance today to create a win-win for everybody by maintaining that status quo. You could retain transparency and the availability to ensure public trust by allowing anyone access to this information. But by retaining at least that low bar and requiring a proactive step to get it, this would help maintain the protection that legislative staff are asking for, and it would show legislative staff that they've been heard in this process. I think from a policy perspective, you could fairly distinguish the decision today from your decision last month by taking a look at the fact that staff serve behind the scenes to support members achieving their policy goals. We have intentionally chosen as staff to serve in support roles. We don't make policy ourselves. And so in terms of if you're looking a fair way to distinguish this from your decision last month, I think that could be a ground for you to settle on. Second point I'll make and then get out of your way. I think you have the ability today to help avoid negatively impacting staff morale by changing F1 treatment. And I'm coming to you based on discussions that I've had with a number of staff. It's received a lot of sort of attention in our office over the last few years. While it's an honor and privilege for staff to serve in the legislative process, I know it's been just a real privilege for me in my career. These jobs are really challenging. Morale, recruitment, retention are longstanding issues for the institution. Staff absolutely love working in the legislative process, but the unpredictable hours, the special sessions, the stressful side of the job causes staff to, every so often, you got to weigh the pros and cons, the risk to reward of the job as staff go through their careers. I know I've done that, and I know others who've spent time in the legislative environment do so. Based on conversations I've had with staff, while this issue may not be determinative as staff make those career choices, I will say that certainly this plays into the pros and cons. The availability of F1 information is not trivial. And I believe that helping retain the status, or your action to retain the status quo, that balance, will be valuable on the morale front as the legislature works to keep and recruit top-level staff into legislative service over what I think is going to be a very challenging next couple of years. So I just appreciate the opportunity to speak with you this morning. Appreciate all that you do, and I think you have the opportunity today to I think strike a balance and create a win-win for both sides. So truly appreciate it, and happy to take any questions.
Thank you, Mr. Gavigan. Appreciate your comments.
Commissioner-
Jana, does that complete our roster of
It does.
requests?
And then just the acknowledgement of the 3 comments that were sent to you afterwards. Would you just like me to say who they're from?
Yes, go ahead.
Okay, give me just a second here. We received a email comment from Christopher Blake. This is in regards to the F1s, and that was sent to the commissioners. The other one was in regards to the possible adoption of revisions to interpretations of 0702 Political Committee Primary Purpose Test. That was submitted from the Freedom Foundation, and that was sent to the commission. The last one was submitted by Glenn Morgan in regards to PDC case 59039, City of Olympia / Steve Hall, and it was his public comment, and all of those comments were sent to the commission.
Thank you very much. I appreciate that. I will keep my comments very, very brief. I would like to thank my fellow commissioners for working through this difficult period and taking part by teleconference, which is challenging sometimes. This is challenging for all of state government, of course, and we're all pulling together and trying to continue our essential tasks and in a safe manner. We're keeping tabs on the state's revenue shortfall, and we'll talk a little bit about this later. The pandemic has had economic jolt for the state budget, and I'm pleased that Peter and the executive team are making plans, contingency plans, and very, very appreciative also of the excellent staff work, full steam ahead. It is no secret that they're trying to do all of their same work with 20% less time and 20% less pay this month with the mandatory furlough this month, and it will be one day a month going forward. And they're also pay freeze for senior staff, and there was a 3% regularly planned pay increment on July 1, so that helped a bit. But we certainly do send our greatest thanks to staff. We're also alert to 2021 legislation that is of interest to us, including work with the House sponsor of the faux mailer legislation that we sent up. I'm also aware that county clerks may be asking for address confidentiality for their F1s. Other legislators have indicated a continuing interest in a broader conversation around F1s and potential redaction of some fields. So we definitely are always open to conversation. We have on our agenda the online availability, of course, as you've heard from legislative staff. So at this point, I would like to ask Director LaValle to give us a brief overview of telework and anything else as regards to staff.
Thank you, Mr. Chair. Like you, I'll try to be brief. I'd say my update is that things continue much as I've reported in previous meetings, that staff continues to do an excellent job of working under the current conditions. The IT team has been very supportive in helping to make sure everybody has a viable work environment and all the equipment they need. That's worked well. We've set up a sign-up system, so when people do need to go to the office to get supplies or use things that are available only in the office, we make sure we stagger those terms, and that's worked really well. Staff morale continues to be excellent. We just had our all-staff meeting last week. We had a good time catching up with people. Of course, everybody is concerned, and rightly so, about the budget situation, and I've done my best to share all information that's available to me with staff about what that looks like. And clearly there are going to be tight budgets for the foreseeable future. But the management team and I continue to work with OFM, the governor's office, and the legislature on making sure that we articulate the impact to the Public Disclosure Commission of any potential decreases in budgeting. As you've heard me say before, we have the fortunate, I guess, circumstance that the commission has concrete data on what a smaller budget for the PDC looks like. Or just a few years ago, where we had outstanding caseloads of 600 open cases and not able to provide the level of support we'd like to, and we had metrics on that we used as part of advocating for more resources for the commission. So we've got all that data that we continue to use to tell the story of what the commission has been able to accomplish over recent years and what a step back might look like. And again, as I have articulated before, one of my biggest concerns, certainly in the current circumstance, is that the public has a somewhat lower level of access to the commission staff and commission activities. But as you've seen this morning, despite having to surmount some occasional technological hurdles, that we are able to accommodate some public access fairly well. So I'm glad we're able to do that, but I am also mindful that it's not the full level of support and openness that we wish we had, and we'll continue to work towards that. Thank you.
And there are no there's no intel from the governor's office as to when state government central offices will be required to be staffed.
That's right. We've had no word on any specifics in that regard. You read the news, as do I, about trends going in the wrong direction in many areas, including Washington, not as bad as some, but so I would read into that we should continue to plan on a great deal of remote working for the foreseeable future.
Is there any questions or comments from the other commissioners? Hearing none, we will hear a little more on budget in a bit. At this point, we'll move to agenda item 2. Is there a motion to approve the minutes as circulated for the June 25th meeting?
I would move to approve the minutes for the June 25th meeting.
Is there a second?
I'll second.
Thank you. It's been moved and seconded that the minutes be approved as circulated for the June 25th meeting. All in favor will say aye.
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 Opposed, no. And so ordered, 5-0. Peter, would you like to, is your budget update succinct, or would you like to hold it until after the docketed 10:15 enforcement hearing?
No, I think we can be quick, and would ask that we do that because Chad Johnson, who had warned us he might not be able to join us each month these days, it has been able to join the call. So while we have him, let's take advantage of that. And we don't have a great deal of detailed news to share. We continue to receive direction from OFM that we should be planning for and modeling a 15% cut in our budget for the next biennium. So that would be beginning approximately 1 year from now. We did a similar exercise for the current fiscal year just begun, July 1. But we've also received promising indications from OFM that perhaps some of the savings that we've identified, short of personnel being affected and the loss of positions, may suffice, but it's early in the process. So while I was able to share what optimism I am able to glean from the signs we get from OFM with staff, I did warn everybody that we should keep in mind that all agencies have been asked to tighten their budgets, and that we keep our fingers crossed and hope for the best, but plan for the worst. Chad, I don't know if you have anything specific you'd like to add beyond the reports that you've shared with the commission.
Actually, I apologize. So my name's Chad Johnson. I'm the PDC's senior financial consultant at DES. So good morning, everybody. Thank you for having me. I didn't provide reports this week because we're smack dab in the middle of fiscal year end. Agencies still have time to get billings out to other agencies, and so the expenditures are a bit incomplete. We're going through fiscal year end now. We received a memo yesterday from David Schumacher stating that although the legislature is not coming to town in August, that agencies have still been directed to work with their OFM analysts where they can to provide or to identify savings and implement those savings items. And so, we may have discussions with OFM over the next coming months about, what can we save, and actually having that, removed from our allotments and put into reserve and reduced from it so that it can be freed up from our revenue forecasts. We've heard rumblings that in September, we're going to see a new revenue forecast, and depending upon that, we may see extensions of furloughs, but that has not been confirmed, but that's just some other information that we've heard recently. So that's all the new information I've got for you guys. We're going to be going through fiscal year end. We're doing our best that we can to save as much as we can, so that's a positive for us. So.
Chad, I have heard rumblings that the governor doesn't plan to call a special session, feeling that the steps that have been taken will be adequate for this calendar year, and that the legislature will get right on it in January. Are you hearing that as well?
Yep, that's what I'm hearing as well. I think that's what David Schumacher's memo yesterday kind of voiced as well. So. That's what we can expect. We were originally thinking maybe the end of August. I'd heard that from quite a few agencies, and now I'm hearing pretty much a definitive no, they're not coming back. So it sounds like what they've probably gotten will help us in the short term, like you're saying, through the end of the calendar year. And then when they get back in January, they'll have to implement something. The one issue that brings up is that once they're implementing it that late, we only have 6 more months to make up that savings. And so it could be very difficult depending on what they decide to implement those savings adjustments because we will only have 6 months to deal with it.
That's right. Any questions of Chad or Peter, commissioners? Hearing none, appreciate your good and succinct and fairly as optimistic as possible under the circumstance. And again, thanks to staff for really working with this and for taking the hit of the furlough days. And we do appreciate and understand that is a sacrifice. Very good. We will move then into the enforcement portion of the meeting.
Commissioner Ammons, I do know
Yes.
that Mr. Hall is joining us via Teams, so we do have that, and it looks like there he is.
Very good. Thank you. And Jeff Myers joined. Are you on the same side by side there? Very good. Let me do this officially, shall we? We're now moving into consideration of enforcement action against Steve Hall, former city manager for the city of Olympia, case 59039. Today is July 23rd, 2020, and the time is 10:17 a.m. We're conducting this meeting as part of our commission meeting by teleconference in accordance with the governor's emergency order 2028 as amended. The governor's order says the public's ability to attend is by remote and that in-person attendance is not possible at this time. The proceeding is being live streamed and recorded and is being conducted under the authority of RCW 3405, the Washington Administrative Procedure Act, and relevant statutes and WAC rules. I'm David Ammons, PDC Chair, and I will be presiding commissioner for today's hearing. I am joined by Vice Chair Fred Jarrett and Commissioners Bill Downing, Russ Lehman, and Nancy Isserlis. I'm joined by Chad Standifer, Assistant Attorney General, who represents PDC staff in this matter. And we also have other staff present today. I will ask them to introduce themselves at this time, although most will not be speaking today. Would you go ahead and, for the record, tell us who is present for the hearing? Peter?
Sure, happy to start. Peter LaValle, Executive Director.
Hi, BG Sandall, Deputy Director.
Hi, Chad Standifer, Assistant Attorney General for Commission staff.
Thank you.
Kurt Young, Compliance Officer.
Thank you. Mr. Hall is with us here, and Jeff Myers. Is Jeff Myers here at your request, Mr. Hall?
Yes, he represents me.
Thank you very much. Would all who are present presenting today be sworn in at this time? If you would raise your right hand wherever you are. Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth?
I do.
And they do. Thank you. The commissioners have read the 140-page report of investigation and have received comments from the complainants and others. So at this time, Mr. Standifer, I understand the parties have reached stipulations as to facts, violations, and a proposed penalty. Would you please present the proposed stipulation?
Can I just interrupt for a second?
Yes.
Mr. Myers and Mr. Hall have frozen on my screen, and it may be that they're not with us. Maybe they should confirm.
They are back now, and I'll watch to make sure if they drop off, I'll definitely watch, but I saw that as well. So they are back.
Okay. He's still frozen on my screen, but there we go. There we go. Good. Yeah, now the hand is moving.
You can't tell if the lips are moving.
That's good to know. All right.
Thank you for noticing that, Bill. So,
Mr. Chairman, I'm sorry. Before we start, I just want to put on the record, I've been personal friends with Steve Hall for 25 years. I just want to put that on a record. I don't think that will prevent me from being involved in this case, but I wanted to make sure that that was on the record.
Thank you for that. And there being no objection, you continue to participate. And I have known Mr. Hall for many years as well, being a local resident of Olympia, and also do not feel that will bias me in this case. Mr. Standifer, would you please now present the stipulation that is proposed?
I will. Thank you, Mr. Chair, members of the commission. I tried to turn my camera on so you could see me. I don't think it's on though. I assume you cannot see me?
I cannot.
All right. So I apologize about that, but at least you can hear me. So I'll take 1 out of 2. Again, for the record, Chad Standifer, Assistant Attorney General, representing the commission staff in this case. As you mentioned, staff and Mr. Hall have entered into a stipulation as to facts, violations, and penalty that has been provided to you for your review, as well as the staff's report of investigation and exhibits in this case. This matter, as you know, relates to a campaign mailer that was sent out by the City of Olympia and was authorized by Mr. Hall in opposition to Initiative 976 last year. Before discussing the matter more specifically as to Mr. Hall, I just wanted to quickly note for the record that staff have dismissed the allegations that were raised in relation to the mailer against the mayor of Olympia, Cheryl Selby, as well as members of the Olympia City Council. As detailed in Kurt Young's report of investigation, there was no evidence found that would indicate or suggest that the mayor or members of the council had specific awareness of the contents of the mailer. And for that reason, the staff has not moved forward with enforcement as to anyone besides Mr. Hall. And I'll discuss some of those facts a little bit in more detail. So to summarize the basic facts of this case, Steve Hall is the former city manager for the city of Olympia, having retired from the position last year. Initiative 976 was a statewide ballot proposition that, among other things, sought to limit annual license fees for vehicles. That proposition was ultimately approved by the voters on November 5th, 2019. Before that, though, on October 8th, 2019, the Olympia City Council adopted a resolution opposing I-976 at their regularly scheduled meeting. Notably, the preparation of a campaign mailer relating to the initiative was not discussed at the Olympia City Council meeting. 7 days later, on October 15th, 2019, the city did print and mail a 2-page publication which did urge voters to vote no on I-976. That mailer was sent exclusively to households with registered voters. The content of the mailer, as detailed in much depth in Mr. Young's report, was developed by city staff, but Mr. Hall was ultimately responsible for the decision to approve distribution of the mailer. The total cost of the mailer was $9,932, which includes both the printing and the mailing costs, as well as the staff time as approximated, the approximated staff time that was devoted to preparing the mailer. Staff's investigation revealed that while Mr. Hall discussed his plan generally to distribute a mailer with the mayor and city council members, there was, again, no evidence that would indicate that any of those folks knew about the particular content of the mailer, including the vote no language. And so that again goes back to the decision to dismiss those allegations against the mayor and the city council members. Turning to the violation at issue here, as you know, 4217A 555 provides that no employee of a public office or agency may use or authorize the use of any of the facilities of that office or agency for the purpose of supporting or opposing a ballot proposition. The statute defines facilities broadly in RCW 4217A 555, and it includes such things as the machines and equipment of an office or agency, as well as the use of office or agency employees. Also in that statute, it is lawful to take action at an open public meeting to express support or opposition to a ballot proposition, as long as members of the public are afforded an approximately equal opportunity for expressing an opposing view. And the city did comply with that provision by giving public time to comment at their meeting in October. It is also important to remind the commission that only individuals can violate RCW 4217A 555. So the city itself as an entity cannot be found in violation of the statute. Also, I wanted to note that in your rules, WAC 390-05-271, parent 2, it states that the statute does not prevent a public office or agency from making an objective and fair presentation of facts relevant to a ballot proposition. So here, it's not the factual information itself that was in the mailer that is objectionable, but rather the use of city resources to specifically urge the public to vote a certain way, as was done here by urging a vote no. So by authorizing the use of city facilities to produce this I-976 mailer, which did in several places urge a no vote, Mr. Hall did violate our CW 4217A 555. Let me turn briefly to the aggravating and mitigating factors which are discussed in the stipulation. Staff has reviewed the factors which are set forth in WAC 390, 37, 182. Turning first to the aggravating factors in this case, Mr. Hall was an experienced city manager and was aware of the prohibition concerning the use of city facilities to support or oppose a candidate or ballot proposition. As I mentioned, the mailer was sent to only registered voters, so did have the appearance of being targeted in that regard. And finally, during the investigation, staff discovered that prior mailers that had been sent out by the city did include the statement that the mailers were for informational purposes only and were not intended to support or oppose the proposition that was discussed in those prior mailers. Obviously, this particular mailer did not include that disclaimer. There are likewise, however, mitigating factors present. Mr. Hall has not been previously found during his career to have violated 4217A or WAC 390. Also, as I mentioned, the use of a mailer, a single mailer presenting factual statements relating to ballot proposition is permitted specifically in your rule and in an interpretation 0402. So again, the content of the mailer, much of it was not necessarily problematic had the vote no language not been included. And finally, Mr. Hall, through his attorney and through himself during the investigation, have cooperated throughout the investigation and the negotiation of the stipulation. And we were able to expeditiously reach a settlement following completion of staff's investigation. I do want to just briefly mention before closing and then taking any questions you might have that staff did look for factually similar cases, but didn't find any. This particular type of violation, 555, these cases are very factually intensive, and there just was not a case that really squared up with this particular matter. Certainly, we found examples of individuals who have been found in violation of the statute in relation to mailers, but nothing that fell squarely with this case. There were a few cases that occurred close in time, about 20 years ago, where similar penalties were found. I can discuss those in more detail if you'd like, but I'm not. But again, we did not find them to be squarely on point here.
Mr. Standiford, I need to interrupt. Mr. Myers has dropped off. Could you give me just 1 second?
Yes.
Thank you.
We are back.
Thank you. I'll keep watching just to make sure. And I apologize if I do have to interrupt, but I'll interrupt if we lose connection, okay?
I'm not sure if it's on my end, if exactly why it's dropping, but we've dropped off a couple of times. And really, it was when Mr. Standifer was starting to explain the aggravating and mitigating factors. So
I'll definitely keep a watch. Commissioner Ammons, what would you like to do at this point?
Well, I would. Do you feel like, Mr. Hall, do you feel like you've been adequately up to speed on what were listed as mitigating and aggravating factors?
I think they've been set forth in the stipulation, and Mr. Standifer, I believe, was covering those in order in the stipulation. If he had other things to add, we didn't hear that. But
did you hear him say that there were no other previous examples of this that were squarely comparable to this matter?
I did not hear that. I would agree with that to the extent he was explaining that none of the previous mailers that the city are exactly on all fours, and nor are there, to my knowledge, examples of this type of flyer that have been the subject of PDC proceedings.
Right. Thank you. So you're up to speed then now. I'm going to, before we get into questions, if the commission will concur that we hear from the respondents at this time, and then we can ask our questions. Is that all right?
Good.
Okay, let's move. Mr. Hall, would you begin? Mr. Hall, can you hear me? I hear a hammer someplace.
Mr. Chair, when we get them back, we might want to consider suggesting that they call in using a landline rather than continuing to unfortunately drop off of the video conference.
Okay.
It looks like we keep dropping off. Is there a phone number we can call in?
Actually, Mr. Myers, let me get your phone number and I'll dial you.
You can call 360.
Wait, first of all, are you okay giving that number over the phone? I mean, we're live streaming. So would you like to email?
I have no problem. It's my office phone number.
Okay, go ahead.
360-754-3480.
3480. All right. Would you guys like to hang up and I'll dial you in?
Okay.
Or do you want to try and go ahead?
We're going to keep trying to follow you, but we'll add the phone connection as well.
Okay. You might get a little feedback, so you'll need to mute the phone. In order to mute the phone, you do *6. Okay.
Right. Okay.
I'll add that in now. Sorry, I will go ahead and dial.
I think we'll pause a minute to let this happen.
Well, I'm attorneys.
Okay, we have you in here as well. So if you'll go ahead and hit *6 on your phone there, that way you won't hear feedback. And then if we need to use your phone, you'll just hit *6 to unmute. I think we're good to go.
Very good. Mr. Hall, you have the floor. And then we'll ask Mr. Myers to add anything that he might have.
So we've lost him. Go ahead and use your phone, *6.
Okay, we're rejoining the video, but
Mr. Myers, if you're going to use your phone, you'll need to mute your Teams, but if you're going to use Teams, you'll need to mute your phone. That's why the feedback's happening.
Can you hear me?
Yep, we sure can.
Very good.
And that works. If you want to leave your video on and use the phone, that works.
That's what
Very
I'm
good.
trying to, but I'm getting feedback on my speakers as well, so you might hear that. There we go. I muted the speakers on the computer.
Great.
So
Look at it.
Anyhow, I think Mr. Standifer has largely covered the basis of the stipulation. I did want to cover a couple of things to make sure that you were aware. The city has in the past regularly sent one-time mailers to communicate to the voters about ballot propositions. In the past, it has not used the quote "don't know" language, or "vote no" language, but those were typically in matters that the city was the sponsor of the ballot measure. This is kind of a unique situation. It was a first-time thing, and time was growing short in order to get a timely message to the voters concerning the City Council's adoption of the resolution. I would point out that there are other jurisdictions that have used vote no language in the resolutions that they have adopted themselves. Olympia used that not in the resolution, but in the mailer. We thought that that language adequately and properly conveyed the message of the City Council in adopting their resolution opposing Initiative 976, as well as the factual impact that that initiative would have on transportation funding in the city of Olympia. So it was based on a good faith belief that we were following the law. But as Mr. Hall indicated in his interview with Mr. Young, in hindsight, we can see a different perspective and see that the language of the mailer didn't pass the guidelines that the PDC has adopted for how those should be prepared. We want to also point out that there's no evidence that this one-time mailer had any impact on the outcome of the election itself, as Initiative 976 handily passed, and this was limited to informing the citizens of the city of Olympia. We didn't try to make a mailer to anybody outside the city, although there may have been some errors in the mailing list that was obtained from the county. So we thought it was a correct presentation of what the council had decided in adopting its resolution. We think that this is a fair and proper resolution of the matter. Mr. Hall was the one who was responsible for the mailer's contents. Even though it was initially drafted by staff, the buck stops with the city manager, and the city manager takes that responsibility and acknowledges it fully. We think it's a fair resolution and ask that you approve the stipulation. Mr. Hall would like to add something at this time.
I have to take this down to talk. Hope you can hear me. So thanks to Commissioner Amons and the Commission for having the hearing. I want to just speak briefly about intent here. So I've been in this business a long time, and the council manager form of government specifically sets out my position so that local governments avoid politics. We stay out of the political fray, which I loved about my job and my career. So we're also in that form of government very good at understanding and following rules. And in this instance, we felt very clearly as pretty seasoned staff that we had followed the rules of the Public Disclosure Commission, that we were following the allowance that we could do a one-time factual informational flyer about the impacts of Initiative 976. That initiative had far-reaching impacts on our community. And as a city staff, we felt we had a duty to let our citizens know that this is a big deal. This is fully 1/2 of our entire transportation budget. So we felt it necessary to do an accurate statement of the impacts. We worked with the City Council to have a public hearing to notify people to speak for and against it. And after that public hearing, our City Council voted unanimously for a variety of reasons to oppose that. So the mailer included the City Council's action at that public meeting that says, you should vote against this. This has big impacts on our community. And so the flyer was intended to factually convey not only the actual impacts, but the actions taken by their elected bodies. So our intent was to follow the law and meet the requirement for a factual flyer, which we did, which we thought we did. And we felt, compelled to take this action so that our citizens knew what this meant. As Mr. Meyer said, in hindsight, understanding the complaints and concerns about the specific vote no language, I think we understand that. But again, I wanted the commission to understand the intent of the staff action taken here. And also just to clarify, as the city manager, I accept full responsibility for the decisions made by the city and the decisions then made by the PDC. So thank you.
I do also want to point out, I don't know if Mr. Standifer covered this because of our technical problems, but the parties have stipulated that, one, Mr. Hall has fully cooperated with the investigation, and that it does not appear that he engaged in any knowing or intentional effort to conceal or violate the law in any way. And that's an important factor for the commission to consider.
Thank you very much. Are there questions or comments by the commission now for either Mr. Standifer or the respondent?
I would have one question, I guess. There was a public comment from Glenn Morgan, who I understand was one of the complainants in this case. There's only one case before us, and that is the case of Mr. Hall. So I suppose what Mr. Morgan has submitted is arguably mitigation for Mr. Hall. But what did we lose them, Jana?
We lost the video. We can hear you on the phone.
Okay, good. Yeah, so my question is really just to give you an opportunity to respond in whatever way you might like to the assertion that there was a wink and a nod, quoting Mr. Morgan, from the city council members, a wink and a nod given in the direction of the conduct which has now been found to be violative of the law.
I'd like to respond to that, if I may. The evidence in this case was that Mr. Hall informed them that they would be sending a mailer, but did not discuss the content with the mayor or with any of the council members, and that he was solely responsible for the content and developing that with his staff. Any implication that there was a wink and a nod is completely factually baseless. Mr. Young, you might want to, or Mr. Standifer might want to address that as well.
Yes, I think that is consistent with what Mr. Young found during the investigation. I think that's why staff believed it was important to conduct an interview with the mayor to make sure that that was the case, and to also interview other staff people, to ask questions of city council, city legal counsel of any contacts that did occur with Mr. Hall regarding the content of the mailer or other staff. And everything that was discovered by Mr. Young is consistent with what Mr. Myers is representing, that while they were aware of the mailer as a general matter being sent out, the actual content and the urging of a vote no is not something that they were aware of in terms of any of the evidence that Mr. Young was able to gather. And since I have the floor, I wanted to briefly note, I neglected to mention that the penalty, as you know, it's stated in the stipulation, but staff is recommending, and Mr. Hall has agreed to, a $10,000 penalty, half of that being suspended based on his future compliance with the law. But turning back to the question, Commissioner Downing, if you have anything further on that, please let me know.
No, I just thought it being thrown out there, I thought that everyone, in the interest of airing this matter publicly, I thought it ought to be addressed.
Mr. Hall would like to address it. Well,
let me just be succinct in regards to Mr. Morgan's comments. They are absolutely bogus and without facts.
I have a couple of questions.
That sounded more like advocacy than providing information.
He's retired now. I would like to ask Mr. Hall, did you ever see the actual draft with the 3 illegal requests to vote no? Did you see that draft before it went out the door?
No, I didn't. But that is typical. I don't operate at that level of detail in my organization, so that's typical. I wouldn't see it. We might talk conceptually about it, but I wouldn't typically review a draft mailer like that.
And
This is Nancy.
You did not direct that it say vote no as part of the text.
That is correct. I did not direct it say vote no.
So you're named party because you're ultimately responsible, but you did not approve that language. Is that what you're telling me?
That is correct, and I am ultimately responsible for the action of my staff.
Nancy.
Thank you. I have two questions. The first is I work with a lot of print shops in my past when I have chaired elections, and it's problematic to me that a print shop would print something without specific direction from someone. Someone has to review the final draft and make sure there aren't spelling errors and all those kinds of things. So I couldn't tell from the report who actually okayed this particular mailer to go out in the mail. So that leaves me with a little bit of discomfort. And the second concern is the actual out-of-pocket expenses to the city, not including time to respond to all of these particular complaints, is just something under $10,000, and I understand that that's probably our limit. My concern is that I wish Mr. Hall well in his retirement, but suspending half of the penalty to make sure that there are no future transgressions probably is a little hollow in my opinion, because he's retired and likely won't have the opportunity to reoffend. So that's just a comment. The second part is a comment, but if someone could answer the question for me, did somebody talk to someone at the print shop to who they got the approval from to actually hit the button to send this thing out?
I think that's a question for staff.
Mr. Young, was that part of your investigation to find out who gave the final okay, the final order to print the text that includes the illegal portions? Can't hear you. Can't hear you.
Sorry, clicking back between mute and unmute. No, that wasn't part of the investigation. I did talk to the communications director for the city of Olympia, and their department did send the flyer to the print shop, but typically we wouldn't confirm that with the print shop, whether it was a advertisement from a candidate or a political committee or from the city or from a jurisdiction using that. And just to address Mayor Downey's earlier comment, one of the complainants, Robert Shirley, after receiving the report of investigation, sent a letter attempting to withdraw the complaint against the mayor and the city council, and that's what prompted us to dismiss that allegation prior to the commission meeting.
Mr. Chair.
Yes.
I guess a question for our staff, either Kurt or Chad. I guess I want to excuse me. I want to echo Nancy's comment about who was responsible. Clearly, ultimately, the city manager is responsible, and it sounds like in this case, Mr. Hall has fallen on the sword and accepting full responsibility, even though it's clear he didn't actually know that language was going to be in there or approve it. I think it's would meet certainly the intent of the statutes to actually ascertain who actually was responsible for that decision, and maybe that person or people should be held jointly responsible with the city manager. But the other thing is, I don't understand why the city attorney is not involved in this, in the fine here. It's clear that the city attorney's office was involved. In fact, their involvement was included in the cost assessment for labor by the city. The assistant city attorney testified that, in fact, they spent time with the city manager, talked about the brochure in detail. And I know from our city and from virtually every city I've ever been involved with, in fact, I've been an assistant city attorney, the city manager or mayor do very few things without consulting with the city attorney on matters like this. So could you explain why the city attorney, why there's only one culpable party in the PDC's mind here?
This is Mr. Stanifer. I think that there's a role that legal counsel plays, and Mr. Hall or Mr. Myers can certainly elaborate on this, but the role that as I understand of legal counsel would be to review things, provide advice, certainly, and we believe potentially advice was given here, although attorney-client privilege has been erased. But ultimately, the decision to go forward with the mailer was Mr. Hall's, not Mr. Barber's, the Olympia City attorney. And then also, I do think staff have a bit of a diverge a little bit with what was stated in terms of what was uncovered during the investigation. I know Mr. Hall has just stated that he didn't approve the vote no language, but one of the interviews that was conducted by Mr. Young was of a staff person with the city, Mr. Hoey, Rich Hoey, and that's detailed in the report of investigation. And Mr. Hoey did indicate that there was a meeting in which Mr. Barber, the city attorney, was present, Mr. Hall, and his recollection was that the vote no language was discussed. We could not delve deeper into that conversation because attorney-client privilege was raised, but I think that in staff's mind, that was sufficient to draw a conclusion that Mr. Hall was aware or should have been aware at that point of the vote no language. So hopefully that does address your question somewhat, Commissioner Lehman. And Mr. Young, if you have anything to add on that, certainly.
No, I think that covers it well, Chad. Thank you.
Chad, are you contending that the assertion of attorney-client privilege shields the city attorney's office in a case like this?
The advice that is given by a city attorney to the city manager is privileged and confidential. As such, there's no admissible evidence concerning what advice Mr. Barber may or may not have given. And that confidence exists as a matter of law and exists for good policy reasons. It exists because you want to give your city attorney and your city managers who are making the decisions the ability to freely confer and discuss matters on which legal advice is necessary and on which subtle nuance makes a difference. You don't want to create a situation where the attorney is rendered liable because of what he may or may not have advised his client. And ultimately, Mr. Hall is the city manager and is the decision maker. Mr. Hall didn't have any direct recollection of seeing that final language. He was not really focused on the language of the mailer and the vote no language. He certainly did not disapprove it. And Mr. Hoey's testimony was that he didn't recall a specific discussion of that but that they did have a privileged conversation, and then he didn't discuss the content of that privileged conversation. That means that there's no evidence concerning what the content of that privileged conversation was.
Except that in the report of investigation, there was a number of paragraphs. I'll try to get up in front of me to cite it specifically, but I recall a number of paragraphs where the assistant city attorney specifically talked about discussion about the actions of the city council in justifying the mailer. So I don't think we need, it seems to me that whether there's an assertion of attorney-client privilege, and of course, Attorney Myers, I completely agree with you. The presence of the privilege is very important. But this individual actually said on more than one occasion that the discussions had occurred specifically about this this mailer, and that the actions of the city council in voting the way they did on the resolution likely justified a mailer. Also, I noticed that Mr. Hall, because he was the consummate city manager, often used the language today, not I, but we. And in fact, everything that he stated was we. My point is not that Mr. Hall is not responsible as the city manager. I just want to be really both careful and appropriate in holding other people that were also responsible for these actions. Mr. Hall said, we felt we were acting, it was always we, and that means Mr. Hall, by definition, wasn't acting alone. Even though he's ultimately responsible, I don't believe necessarily by the investigation that he's necessarily the only one responsible. And that's not for you, Mr. Hall, or Attorney Myers. That's, I guess, for my staff, for Kurt and for Chad. I guess I don't want to belabor this, but I don't feel like I have a really good handle on why others that were clearly involved and had responsibility were not also held responsible.
And let me just confirm that when I commented earlier that what Mr. Morgan had submitted may have been in the form of possible mitigation for this particular respondent, that is really the only relevance of it for us today, other than going forward basis. And given the opportunity to respond to it as potential mitigation, Mr. Hall denied that strongly.
Chad, do you have any further response to Commissioner Lehman's point?
Well, I think I just want to understand in terms of others potentially being responsible. I'm not sure if you're meaning somebody beyond Mr. Barber, but certainly there are other staff people involved with developing the mailer. But Mr. Hall, again, was ultimately responsible for approving it and really the one to be responsible for compliance with BDC laws and regulations. But in terms of Mr. Barber, again, I think there are circumstances, the attorney-client privilege is not absolute, certainly. But I think to pierce it, we would have to have some evidence that there was approval by Mr. Barber, or that he had a role beyond giving advice. That's at least staff's perspective. And again, I don't think Mr. Young uncovered anything that would indicate, just the nature of his position is not one that's where he's in an approval or responsible for the budget, responsible for making decisions in this regard. So that's why staff did not turn their attention to him in terms of being a potential respondent.
Chad, was there any discussion or any thoughts, even in your own mind, about dividing the penalty in any fashion?
when you say dividing
amongst several players, I certainly noticed some people who had major fingerprints on the offending mailer, and apparently from testimony from Mr. Hall were the ones that actually put those three vote no stickers all over the mailer that clearly broke the law. So again, is there any way, and perhaps I'm thinking of the precedential value of this case and going forward, if other local governments or any state government for that matter were to put out a mailer like this, who takes the hit for it?
Well, staff believe that PDC staff believe that the staff developing the content of the mailer were taking their cues from Mr. Hall. And in terms of the resolution itself was a vote no, and that they were developing a mailer consistent with that resolution. And so while he may not have delved into the minutia of the mailer, they understood what the mailer needed to say from him. And so I don't think staff believed it was appropriate to try to hold accountable folks that were working at the direction of somebody else and who were in a lower level capacity. There's also, I don't believe, much precedent in this regard, and Mr. Young or others can jump in on this, but I don't believe I've seen cases where lower level staff, unless maybe you have an egregious violation of misuse of public resources, public facilities, are going to be the ones that are on the hook in a situation like this. So I don't know. Kurt, Mr. Young can jump in, or Mr. Director LaValle as well if they'd like.
Mr. Chair, Mr. Hall would also like to be heard on this question, and I'll defer to Mr. LaValle if he wishes to jump in.
I think the question was addressed to Kurt. An opportunity to speak, if you wish.
I see Peter's on there. I'd yield to him initially.
Okay, Peter.
Mr. Chair, I was not sworn in. I'm not sure what I'm going to give as testimony, but to be safe, perhaps you should quickly swear me in.
Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter testimony that you will give today?
I do. Thank you.
Thank you.
So a couple of points I wanted to address is that as far as precedential value, by all means, that we as staff will continue to look at culpability at all levels in future misuse of public resources, public property cases going forward. So by no means is this the case? I don't take the resolution of this case as a precedent that says never will a lower level staffer be held responsible, never will a higher authority be held responsible, and never will a legal counsel be held responsible. But under the facts of this specific case, we were quite comfortable that Mr. Hall, as he comes before you and testifies to himself, was responsible for this decision, and people acted at his behest and his approval. And I did want to say to Commissioner Lehman's points that he raised, or his concerns he raised, that when Mr. Young came to me with his initial conclusions, at the risk of delaying resolution of this case, knowing that it is something that was in the public eye and people were anxious to have resolved, no one less than the commission itself, that at the risk of delaying that, I did ask Mr. Young to go back and conduct additional interviews because I wasn't personally yet convinced that there weren't other culpable players here. And Mr. Young did go back and do additional investigation that brought me to that comfort level. So it was a concern of mine. So I did ask to make sure that we ran down every avenue possible, and I think we did. So I'm comfortable with where we stand with this today.
Thank you very much. I had one other follow-up question for Commissioner Esterlis's comment about usually when we suspend part of a penalty, it is to hold that hammer over that person or organization going forward. But as she pointed out, Mr. Hall has apparently retired from public service, and so I'm wondering thoughts about the $5,000 forgiveness piece of it.
Yeah, let me say first as a general matter that when we bring proposed penalty before you, it's often the subject of complex negotiations, and we bring it to you as a package, and that was certainly the case here, as it usually is. And I don't know, and I know Mr. Hall is waiting to weigh in on the discussion we've just been having as well, so I want to recognize that. But and he may want to weigh in this point I'm about to make as well, and that is Mr. Hall is retired from his position as city manager of the city of Olympia, but as a actively engaged, civically active individual, may very well have activities with whether it's public service directly or campaigns or other advocacy in the future, that suspended penalty will continue to be an incentive, I would say. So it's not tied directly to his former position.
Thank you very much. That's appreciated. Kurt, did you have something?
Chair, just one last comment from me on Commissioner Lehman's inquiry.
Yes.
We did have cases in the past involving a school district where multiple employees went beyond their authority and individually undertook activities that supported a bond or levy in the school district. And in those instances, we might have charged the superintendent and some principals and some public information officers, but it also got down to line employees where they actually forwarded emails and undertook activity that were outside of the scope of their duties and without approval from the superintendent or a principal or whoever might be. So, when the facts warrant, we do go beyond just, charging the person responsible if we do have facts to that.
Very good. Thank you. Mr. Hall, did you want to say further?
Just briefly, and I know you've moved on beyond this point, I just want to go back to the issue of delegated authority. So in the council manager form of government, a communications director, a city attorney, a public works director would not make a decision to print a brochure like this on their own. It's a delegated authority that I gave to them to release the brochure, but it only came as a result of me delegating the authority. So when I delegate authority, I have then the option to review every detail of the brochure going out. If I choose not to, which I did in this case, I am still responsible because I have delegated that authority and told someone, go ahead, I don't need to look at it. So I just want to be clear that of everything we've talked about, the responsibility for the production is mine and mine alone. Thank you.
Thank you. Are there any further questions or comments at this point, commissioners? I'm wondering, our options, of course, are to accept or the proposal or reject it or modify the stipulation. If the commission rejects the stipulation or if a party doesn't agree to propose modifications, then an adjudicative hearing is scheduled or the matter referred to the Attorney General. I would ask the commissioners if you would like to take an executive session break. I'm seeing one nodded head. Anybody else concur with that? Well, we will then, if there's nothing further of staff, I want to make sure that those questions have been answered to your satisfaction before we confer with council. Hearing nothing further, we will be in recess to meet in executive session, which is authorized under our RCW, and we will be back as soon as we can. We realize there is a docketed agenda item at 11:15, which we clearly are not going to make. So we will be adjusting our agenda as we move forward. So we will now be in recess, and the commissioners and council will meet in executive session. Thank you.
As a reminder to commissioners and council, you can use the previously scheduled executive session conference for that purpose.
Right.
And
Thank
Nancy, why don't I, since you had problems with the link, I will resend the link directly to your email. And then also, if I need to, I will call you to give you the information or call you in. So if commissioners, if you can leave this, everybody that's on the stream right now, the meeting will still stream. Please mute, and commissioners go ahead and leave and join the executive session link and then come back. Thanks. Commissioner Ammons, we are streaming live. I know we're still waiting for commissioners, but I need to let you guys know that we are streaming live right now. Looks like we have 4 of the commissioners just waiting for Commissioner Isserlis. Jeff Myers is back in. Let me check my email to see if Commissioner Isserlis has had, oh, there she is.
I'm here.
Great deal, good. Commissioner, you are back. You are muted right now. There you go.
Welcome back to our hearing on this matter, this enforcement matter involving the former city manager of the city of Olympia. We have completed our time in our executive session, and I would be open to a motion.
This is Commissioner Downing. I'll go ahead and make a motion that the commission approve the stipulation as presented as to the facts, the violation, and the penalty. I think that there's a general perception among us that there is culpability to be shared both up and down the line in the city of Olympia. It's certainly commendable that that Mr. Hall is accepting the responsibility for those up and down the line. Certainly it is an appropriate place for the responsibility to fall. And it's, again, commendable that he has recognized that. I think it's also commendable that although he initially felt there was justification for what occurred, in hindsight has come to the clear conclusion that the line was crossed. That the advocacy that was engaged in the mailer, the way in which it was directed, and so on, all constitute violations of the law. So I think that while there still is some equivocating on that subject, I think that's appropriately noted as well. So I would move that we accept the stipulation as to the facts, the violation, and the penalty.
Is there a second?
This is Nancy. I'll second.
Thank you. Are there further comments from commissioners? Hearing none, we will move to final vote. One last chance for commissioners. Okay. Hearing none, we will now vote. All in favor of the proposed stipulation as to facts, violations, and penalty in case 59039 will say aye.
Aye. Aye.
Opposed, no.
No.
The motion is carried by a vote of 4-1 with Commissioner, excuse me, with Commissioner voting no. Thank you. We will, if there's nothing further on this motion or this portion of our agenda, we will complete this enforcement hearing. Thank you very much. And
Mr. Myers, Mr. Halls, you're welcome to stay on the meeting. Otherwise, you're welcome to disconnect.
We have lost our video feed, but still connected by phone, and want to thank the commission for the resolution of this matter.
You're welcome. Thank you for joining us, and thank you to Chad Sandifer for his end of the discussion.
Thank you, Mr. Chair, members of the commission, for your thoughtful consideration of this case.
At this point, we will move to our next agenda item, which is discussion of potential action on online availability of legislative F1s. If you'll give me just a moment to get my papers in order. So this is not a new issue for this commission. It has been considered thoughtfully over a number of months, as has the entire issue of online availability of F1s for all filers. And so we bring that understanding to the table. We have listened to a lot of voices, including staff. Last fall, the commission directed staff to make F1s available as of January 1, make them available online, as all of our other records are online. At that time, we did carve out an exception for the legislative professional staff until May 1st, giving the legislature another session to consider alternate handling of these reports. The legislature adjourned without considering or dealing in a conclusive way with that issue or our addressing of F1 changes in general that we had also sent up. Committee chairs from both chambers then requested an extension of until after the 2021 session. And some senators requested that last month that all F1s be kept offline, and the chief clerk of the House and the secretary of the Senate asked that professional legislative staff reports specifically be kept offline. The commission last month did vote, or confirmed, I should say, an earlier vote to resume online availability of all of those other F1s. The one piece that was not taken up in that action was legislative staff F1s. The commission voted to extend that original May 1st deadline until after this July meeting to see if there were any concrete proposals emanating from the legislature for dealing with this group of filers. So that's where we are today, as I see it. In a moment, I'll ask Peter and Fred or anyone else who has any updates on conversations with the legislature about this group of filers. I would say that if the commission takes no action today, our previous motion will kick in. The new filers filings will be available online starting tomorrow. So I would at this point invite our director, Peter LaValle, to tell us what has transpired and whether there are any concrete proposals for dealing with this group.
Thank you, Mr. Chair. I have made some outreach to some key legislators who have expressed interest and worked on this issue in the past. And perhaps understandably, I think they had other priorities at this time. So I do not have any concrete proposals to share with you. I hope to continue those discussions, whatever the commission chooses to do today, because this and other issues I know are going to continue to be a focus of the legislature that are relevant to the PDC. So nothing specific to share with you. We're all aware of some of the ideas that were floated in the past that may or may not still have some relevance. But that's the news update I have, such as it is.
Thank you. And are there any other commissioners who have been privy to any conversations around dealing with this set of filers? Hearing none, I would just ask for if there are any comments on where we're at today. As I mentioned, if there is no motion to extend our earlier position on this, then the alternative, in the absence of a motion, will be that it will automatically take effect tomorrow. Commissioner Jarrett.
Yeah, I had one question. I was going to ask Peter if he would respond, and it has to do with the work that we've done over the last year and a half or so in terms of analyzing the individual elements of the F1 and which things are sensitive. And this came up in a number of the comments from the staff about how the combination of this information is something that is in fact sensitive, and specifically around whether there are elements of the F1 which normally would be exempt from the Public Records Act.
Thank you, Mr. Vice Chair. We did, as you know, go through an extensive process of reviewing all the information that is included in the F1. We've looked at what other states do, both in terms of what they collect and how they share it, how they make it public. And we did get a lot of stakeholder input on what's contained in the F1. I would anticipate that's going to continue to be the case even after we get through this current issue before the commission, that we'll want to continue on an ongoing basis looking at what information we collect and is it relevant, and are we collecting the right information, are we making the right information public? There were not a lot of easy answers as we went through that, because there are elements to be balanced between transparency and privacy, and as I've mentioned before, the one low-hanging fruit that we seemed to come across was children's names, that people did not see a great public interest in disclosing the names of children of a filer who might have assets in their name, and people did see a great privacy interest in that. So that was the one easy one to address, which we did. We also have gone through an extensive process in anticipation of putting F1s online, of contracting with an outside vendor to review thousands of F1s for any sensitive information that we don't require but does occasionally get submitted. For instance, somebody might submit a brokerage account number that we don't ask for, or a social security number might inadvertently be left on an attachment, something of that nature. And we found a handful of those and reviewed them. We PDC staff reviewed what that vendor discovered and came to the conclusion there were, I think it was about 16 items that needed to be redacted. So we do redact anything that is exempt and is not required to be disclosed. So we've done our best under the current requirements of what's collected and what we are allowed to exempt to make sure that we're disclosing only what is part of the public record and ought to be part of the public record. So I hope that helps address your question.
Other comments or questions? Are there any motions? Peter, no, Peter. Fred.
So I just would want to remark that as a state, we have a long tradition of transparency and openness. And while I'm very much in favor of always looking at what evolving technology and, both in terms of increasing transparency and also in terms of increasing risk, I think we have an obligation institutionally to making information available in the easiest way for the public to be able to get at it. And will speak at this point as opposed to a motion and in favor of continuing with our plan to bring this information up. I think the public has a right to know of people who are in the decision-making process, what their personal interests are. And I think that it's not our job to determine who should be subject to these reporting requirements, but it is our job to make, once those requirements are in place, it is our job to make sure that they're available to the public.
Thank you, Fred. Russ, any of the other commissioners want to be heard?
Well, I completely concur with Commissioner Jarrett, and at this point, it looks like there's no motion to be had. So there's, I think, I will not take the time and the effort to have further discussion on this. This has been since the spring of 2018. This commission has spent an inordinate number of hours on this issue, and I think we're ready to move on. And I appreciate Commissioner Jarrett's comments.
Hearing no motions or further comments, I will declare this portion of the agenda concluded, and the staff will be directed to make those reports available online tomorrow, if that's possible, with the furloughs, but as soon as practicable.
Chair Ammons, if I may, this is James Guthom, the
yes,
CIO. And just for the members of the commission as well as the public who is following the meeting, they will not be online tomorrow. That there is a technical change involved because we were securing access to those. And so we will shoot for the middle of next week, earlier if we can. But right now we're probably looking at the middle of next week.
Thank you very much. I presume there might be some delay that would be required, but I appreciate your standing by to do that. I think with that, we will conclude that part of our agenda, and I believe we have time to do the rulemaking, interpretations, and legislation piece. BG Sandall, our Deputy Director, and Sean Flynn. I know we have our possible adoption of our of our interpretation on primary purpose test, definition of a political committee. Do you have anything else, BG, before we go right into that? You're muted.
Yeah, you probably want me to be, but anyway, thank you very much, Commissioner Ammons. Just a quick overview of sort of the next steps of our permanent rules process. What's going to occur is, and these are for the donations to the foreign national corporations, as well as a handful of F1 rules, which I believe Sean and Kim spoke to you about at our last meeting. And what our schedule looks like right now is that Sean will draft rules, get those out to you either late August, early September. He's going to ask that you individually submit your comments back to him. I think, you know, having done rules for some time with the agency, I think that's probably a cleaner way to do it. He will take your comments, prepare a document for those, and those will be available for your discussion at our September meeting. After the September meeting occurs, Sean will take your comments again. We will create a new document with the rules. We will file a CR 102. At that time, we will also let stakeholders know, as well as inclusion on our website, of what those changes are looking like. So the public will have ample time to look at the changes, make comments. Then in our December 3rd meeting, we will hold a public hearing for that to allow the public to come and make their comments. And that's kind of where we are with that. The couple things I want to mention is the current emergency rule will expire in October. So we will need to extend that emergency rule. The extension will go until about February 11th. So Sean and I are working on the process of ensuring that that the permanent rule process will actually be completed prior to the extension of the second of the emergency rule. I just also want to mention to you that because this is a new law, we are anxious to find out from filers and you know, people having to report under this, what they found, you know, what kind of challenges did they have. So that's kind of a reason why we're sort of waiting until December to hear, is we want to be able to analyze those as staff to present to you as well. So with that, does anyone have questions? Make sense?
Sounds good.
Okay.
Good plan. Okay,
thank you.
Sean, this is the umpteenth iteration of this. You have done a wonderful job of engaging stakeholders and reviewing drafts with us and with the public. And so here we are for potential adoption. Would you give a high-level explanation of what this is, and then we'll be open to questions or potential amendments from the commission? You're muted.
God, I was trying to be the one that didn't forget. There I go. Thank you, Mr. Chair, and I will try and be brief with my comments, but I'm definitely open for any questions commissioners have to any part of this. This is a update of our guidance that we give on the primary purpose test which is a court-developed test used to determine when an entity becomes a political committee for purposes of registration and reporting regulations under our law. It's a test that's been around for a number of years. I won't go into articulating that. The basic premise is that it's used to determine when an entity has made sufficient expenditures in campaign activities in the state as to trigger this requirement. It's not used for when an entity receives or solicits contributions. That would be a separate test or a separate standard used. As I said, it's been a test that's been around for a long time. The commission has used it. In 2007, there was an interpretation that that basically just went over the current case or the case law up to that point, that had defined and reaffirmed the law, and also gave some guidance as to the factors that courts would use to apply the test. We had found that, over the course of, some time that we just needed to kind of brush up the language there, make sure that it was succinct. There had been some more recent cases that we wanted to make sure were cited in there. But basically the intent is to reaffirm that the commission will use this test as clearly established in the case law. And so it doesn't really do much of a substantive change. It's not intended to. It's just to be a clear articulation of the test, to reaffirm the commission's use of the test. The one area that I guess I will point out that there is some changes, if you look at the draft that's given at the bottom of that, the second to last paragraph, is some new language that we thought would be helpful to filers to add in there to give a little bit extra guidance in addition to the factors that the courts use in determining whether a threshold has been met or whether the test has been satisfied. The only downside of the test, I think, that we can say is it seems to work well in retrospect, but doesn't always work well prospectively. So, how is a committee supposed to, know that it's meeting all those factors when it's in the course of doing its business? So we added the a 30% kind of threshold. I don't want to call it a threshold, but just a guide that we were explaining that when an entity hits about 30% of its expenditures of its budget that's being dedicated for the use of political expenditures, then it really should start to consider those factors and consider whether it should be filing as a political committee. In the first draft had that language in there in response to some comments that we received at the end of last year. We wanted to ensure that the 30% would not be used as an enforcement tool, or is not intended to be used as an enforcement tool. It's not intended to be used as an additional factor that the courts that would be added on to the court factors. It's really just a way to try and give filers some guidance as to when they should start to think about these things, like this is where things should initiate. I'll refer briefly to the comments that we did receive on this. Basically, there were two lines of thought. One was that the 30% was too low, and one that it was too high. Generally, I think that gives me some comfort when you find yourself in the middle of two perspectives. But they were, there was some good, reasonable issues raised on both sides of that. First of all, that 30% may, in some cases, be too low in an indication, and in others where a committee has already, sort of surpassed that primary purpose test. So 30% would be too high a threshold. I won't go into responding to those. We've discussed this in the past. I've kind of given my assessment of that. I think the bottom line, and not to try and characterize too much, but I think the bottom line in both concerns is that there was possibly too much weight being put on this as being a determinative factor that we would use in enforcement, and that's why some of the revisions we made to the draft was to try and make sure that it's clear that this is not a determinative factor. This is not something that creates a presumptive threshold that we would use in enforcement. It really is to just try and be on the prospective side for giving filers a little bit more guidance. That being said, your 30% is admittedly an estimate. There's no magic formula that reaches there. It seemed the reasonable approach for staff as we consider this, and where in enforcement cases, a lot of times that's where things kind of play out. But again, it's just an estimate, and so I'd be happy to discuss that or answer any questions you may have towards that. The last thing I'll say before I'll finish up here is there's just a couple technical issues I would appreciate your indulgence in being able to amend from this draft. Unfortunately, when I was looking over it this morning and reviewing, I realized that there was an updated court citation that I wanted to add in there. You'll recall the GMA case was decided earlier this year in the Supreme Court, and there was some language in that decision about reaffirming the use of the primary purpose test for purposes of the expenditure prong of a committee's activities, and that it doesn't apply to contributions. I thought it was a good, strong statement from the Supreme Court, and I want to make sure that is that citation is added to this. So that would be the only amendment that I would appreciate your indulgence in being able to put in there. But other than that, this is the version that we would recommend for your approval.
I think, hearing no objection, that the citation of the GMA case would certainly, I think, would make sense. So I would proceed with that addition to your draft. Are there other questions? Commissioner Jarrett?
I would just make the comment that I'm not persuaded by the 30%, and I tend to be persuaded by the 20%. For me, the point is not that we're looking at the primary purpose of an organization, but a primary purpose of an organization. And it seems to me when you get up in the range of a fifth of the effort of the organization, you're probably in the range of a primary purpose. So I would be supportive of lowering that number from 30 to 20. Understanding all of the other comments that Sean made about it not being a threshold, that it being something just to give you an indication. It seems to me to be in the current environment and the world that we live in, a little more transparency and a little bit more openness is appropriate.
Do you so move?
I so move.
Is there a second to amending 30 to 20? The motion dies for lack of a second. Further comments? Are you ready? Is there a motion to approve this draft today as with the amendment that that staff will be adding regarding the GMA language? Is there a motion to approve this as a new interpretation of the commission?
I would move to approve this interpretation as a interpretation of the commission.
It's been moved that the, is there a second to that?
Second.
It's been moved and seconded that the commission approve the proposed revisions to our interpretation and as circulated widely and as will be with the agreement that the GMA language will be added to the final document. Further comments?
You know, I'm just looking at it on screen, and when I read it yesterday, I thought I spotted a typographical error, non-substantive. I can't find it now, and I didn't highlight it or mark it or print it or anything like that. So I'll let you know later on, Sean, if I spot it, and if it's, I think it could be corrected if that's the case.
Bill, I saw it. It was a 3 where it should have been a 2.
Nice try. Nice try. Well, all in favor will say aye.
Aye.
Aye. Opposed, no. The interpretation is approved by a vote of 5-0, with much thanks to Sean for bird dogging this and working with stakeholders and so forth.
Well, thank you, and stay tuned. We'll have another one hopefully prepared for you by the end of the year.
Thank you very much. Appreciate that. BG, is there further from your team? Hearing none.
Sorry, no.
No.
Kim sent me an email that said, turn your camera off. And so if I was making faces, I was reading emails. It wasn't directed toward any of your comments.
All right. We have completed our morning agenda, and so now we will proceed to do our executive session that will be limited to matters that are legitimately discussed with council and other matters, and no action will be taken in that session. We have plans to return at 1 o'clock for reporting modifications. I would ask the commissioners and those who ordinarily come to our executive session to convene in 10 minutes, give you a little break and go make a sandwich or something. And so we will meet about 12:15 in our separate space.
Commissioners, if you have any problems coming into the executive session, go ahead and email me and I will pop into the session and try and get you in.
Thanks.
For those that are staying on, the stream will still go on. Go ahead and put yourself on mute and we'll come back. Commissioner, you are live.
Very good, and welcome back to the July 23rd meeting of the Public Disclosure Commission. We will now move into a full commission hearing on requests for limited modification in F1 reports. We have 2 new requests and 2 renewal requests. For the record, the date is the 23rd of July, and the time is 1:03 p.m. We are conducting this hearing as part of our regular meeting by way of teleconference pursuant to the governor's emergency proclamation 20-28 as amended and extended. I'm Commission Chair David Ammons. I'm joined by Vice Chair Fred Jarrett and Commissioners Russ Lehman, Bill Downing, and Nancy Isserlis. We're also joined by staff and council and compliance coordinators. We are conducting these hearings under the authority of RCW 3405, the Administrative Procedure Act, and relevant PDC statutes and rules. The hearings are being live streamed and audio recorded. By way of background, elected and certain appointed officials in our state are required by law to file what are called reports of financial affairs and gifts, also known as F1s. The statute spells out that what they must report and allows a filer to apply for suspension or modification of one or more of these requirements. The filer does this by submitting a written request for consideration, and a hearing is held. Filers may appear in person or by phone, or waive their appearance and rely on written materials provided. So we have today, as I mentioned, 2 new requests, and we will start with State Senate candidate Arthur Cody, and he is on the line already. And who will be presenting this case?
This is Tabitha Townsend, and Arthur is on the line as well.
Very good. Arthur, we would have you be sworn in at this time so that you'll be able to make comments or answer questions of us. If you would raise your right hand there where you are. And do you swear that the testimony you are going to give today in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Very good. He does. And so we have read the complete file and the request and any materials that were submitted, and we will ask our staff to present the high points of this for us. Thank you.
Dave, would you swear me in first?
Good point. I should have sworn in both of you at the same time. Do you will you be sworn in? Do you swear or affirm that the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Proceed.
Okay, so this is a new candidate modification request for Arthur Cody. This is for personal residence and other. Due to a safety concern, Arthur Cody is requesting a partial reporting modification that would exempt him from disclosing the following information for himself, his spouse, and his dependent. The income information would be the name and address of the reportable income sources. The real estate would be 2 properties, 1 residential address and 1 additional address, both of which are frequently used by his family. And then business associations, the names and addresses of reportable business associations. They have disclosed the income and assets figures without the names and addresses already. Arthur Cody states that due to the nature of the threat made, the release of this information presents a safety risk for his entire family. Mr. Cody indicated that police involvement was necessary to address his safety concern. In the interest in the interest of transparency, Arthur Cody has disclosed the values associated with the reportable income, real estate, and business associations for himself, his spouse, and his dependent on his F1 report already. Mr. Cody confirmed that his concerns regarding income and business associations is confined to reporting these entities' names and addresses. He has agreed to recuse himself if a matter came before him involving a conflict of interest between his personal interests and public duties. PDC staff has informed Arthur Cody of the residential address reporting alternatives set forth in WAC 390-24-200. Arthur Cody's records would be exempt from public disclosure if the Commission finds, in accordance with RCW 4217A 120 and WAC 390-28-080, that disclosure of such information would present a personal risk to a reasonable person. Being that this is a candidate request, the request would only be for this report, and if elected, he would have to reapply. And I'm available for questions.
I was interested in whether there was any evidence given of a continuing real threat. The threat that was mentioned is 12 years old. There's nothing in the record to say that there is something that is more tangible or that a protection order is currently live. Could you tell us more about that and whether it falls within our ability to consider this a safety risk?
I was not provided with an order of protection. Maybe Mr. Cody could address that and let us know if there is one.
Can you folks hear me?
Yes, we can. Thank you.
If you're talking about a court-issued order, no, there's not. At the time of the incident, I inquired of law enforcement if they thought that would be helpful, and the general consensus was no, it would not, because unfortunately the threat was issued by a very mentally ill, unstable patient who we didn't think an order would really have any weight with this individual.
The state law that we're bound by in looking at matters of personal safety require a showing of a present continuing threat, and with some instances of it, and not a generalized threat because of the office held or sought. So I'm still looking for something that would give us any kind of leg to stand on.
I mean, I'm not aware of any evidence of a continuing threat, but the problem in these situations is that, when you have patients like this who are mentally ill and sort of obsessive about things, they tend to have long memories, and so you never just let go and think, well, I can just ignore this. I mean, the advice of law enforcement and common sense prevailing is you have to continue to take precautions. That never sort of goes away. So has this individual, done something to my knowledge since then to, raise the ante on this? No, not to my knowledge, but it was a very credible threat when it was made, and he threatened to involve another individual in executing some sort of a plan, and so I think out of common sense, I think anybody who experienced anything like that would never look back on it and say, well, it's not a problem anymore. you have to consider it a potential problem indefinitely.
Would you have any further comments, Doctor, at this time that we have not just covered?
No, I don't think so.
Any commissioners have any questions?
I mean, I guess I would.
Have you run for office? Your name is familiar to me for some reason as an old political reporter. Have you have run for office before? Have you not?
I have.
And have you divulged information such as is being requested in the F1s before?
I don't recall I've run for federal office most recently, and
right.
I do not recall any such reporting requirements at the federal level. I did run for a state office 10 years ago, and I honestly don't remember what had to be reported then, though certainly since that time my personal residence has changed, but I don't remember at the time what I reported.
Tabitha, could you answer that question about prior F1s for that are on record for him?
We have 2 prior F1s from 2010 and 2016 for Mr. Cody.
And do they include the information for which he now seeks a modification?
The reports are not necessarily visible to me in the view that I'm in right now. I can pull them up in a different manner.
I could make one comment for you. In 2016, I did not actually file to be on the ballot. I had contemplated running for a state legislative position and ultimately did not file to be on the ballot. And I don't recall actually completing the F1.
Did you file an F1 within 2 years of this incident that you recall?
It would have been approximately 2 years after that. I don't know if it was exactly or not.
And you did not seek modifications at that time?
I don't remember doing that. Again, that's been 10 years.
Well, thank you very much for that background. Is there a motion on this particular request? Or further questions for that matter? Bill, you're muted, Bill. Commissioner Downing?
Coming on.
There you go.
I'll make the motion that I think all of us understand. It would be a motion that the request for modification be denied based on a failure to prove the necessary elements. In this case, I've never seen one where there's so much redacted. I mean, a medical doctor and somebody involved in watch manufacturer sales, those are things that involve the public. There are 35 other things on the list here that should be publicly accessible as well. In addition, and most importantly, I guess, is the old age of the concern at issue. So I think that clearly the granting the motion would frustrate the purposes of the act. There's an insufficient basis for doing so, insufficient basis for finding an unreasonable, manifestly unreasonable hardship. So the burden of proof not having been met, I would move that the request be denied.
Is there a second to that motion?
Second.
Further discussion? All in favor will say aye.
Aye.
Opposed, no. The commission has voted by a 5-0 vote to not grant the request for modification, to deny the request.
Chair Emmons, can I get the first and second who made the motions?
Everybody seconded. Just Commissioner Downing made the motion and everybody simultaneously seconded it.
You pick.
Thank you.
So this concludes our consideration of this particular case. And thank you for joining us today, Doctor.
Thank you.
Next, we have, we're going to call Kevin Ranker.
Correct.
I'll dial now. Just give me a moment here.
Hello, this is Kevin.
Hi, this is Janet from the PDC. I have you in the hearing. The commission chair will be here in just a moment.
Hello, Mr. Ranker. This is David Ammons, chair of the commission, and all four of the other commissioners are also here. And we have read your request in full, and I will swear you in so that you can be heard and answer questions if you wish. If you would raise your right hand wherever you are, and remotely be sworn in. Do you swear that the testimony that you will give today in this matter is the truth, the whole truth, and nothing but the truth?
Absolutely.
Thank you very much for that. And at this point, the commission would like for staff person to present this particular request.
And this is Tabitha Townsend again. This is a partial modification request for a candidate report. There are two parts. There's a renewal with change, and there's also a new request. So a little different than we're used to. The renewal with change is going to be the income and ownership interest. And the new request is a personal residence safety matter. Again, it's a candidate request, so if granted, it would just be for this report, and he would have to reapply if elected. Kevin Ranker is requesting a partial reporting modification that would exempt him from disclosing his residential address due to safety concerns. He is stating that the safety concern is a threat he received before he retired from his Senate position January 9th, 2019. Kevin Ranker is also requesting a partial reporting modification renewal that would exempt him from disclosing business customers that paid $12,000 or more during 2019 to Coastal Consulting LLC, a firm he owns and serves as CEO. Kevin states that Coastal Consulting provides executive coaching services to senior managers, which requires absolute confidentiality. He also states that there are two customers reportable on the F1, and only one of the customers is needing to be exempt due to confidentiality agreement. The other has been disclosed on the report in an effort to be transparent. Kevin Ranker states that disclosing the customer list would put Coastal Consulting LLC at a competitive disadvantage, as clients would no longer contract with the firm. Kevin Ranker states that there are no governmental customers to be released and that he has no payments from the state of Washington during 2019. He has also agreed to recuse himself if a matter came before him involving a conflict of interest between his personal interests and public duties. Kevin Ranker has reviewed his initial report modification request and any subsequent renewal requests and has certified that there are no changes to the facts related to his request, other than the change of the company from, I forget the name, sorry. It's Global. It's now Coastal Consulting, and the two companies run for local businesses that he coaches and for businesses that might be out of the country. So the current one in question is in the country and under Coastal. PDC staff has informed Kevin of the residential address reporting alternatives set forth in WAC 390-24-200. Kevin Ranker's records would be exempt from public disclosure if the commission finds in accordance with RCW 42-17A-120 and WAC 390-28-080 that disclosure of such information would present a personal risk to a reasonable person. And I'm available for questions.
You are referring to exemption from disclosure just of the residential piece.
Correct.
Not all of his record. We might make that clear in the future in our write-ups.
Okay.
I would plan on dividing the issue here for our consideration, the income and ownership interest piece, and then secondly, the personal residence shielding of that address. I would first of all ask if there are any questions of staff.
Yes. I'm sorry, Fred, go ahead.
I need to disclose the fact that Senator Ranker and I served together on the floor of the Senate and made great mischief back in the day. But I don't think that will affect my ability to judge him harshly.
No, but that association could be enough reason for the rest of us to vote against it. Could I ask a question, Tabitha?
Yes.
Did Mr. Ranker file this information in his F1s when he was in the Senate?
The address or the?
No, I'm sorry.
I'm sorry.
I'm sorry, not the, well, actually, I guess the address too, but the income request for modification. I'm curious whether he was granted such a modification for that exact information when he was in the Senate.
Yes, the previous income and ownership was last granted on May 24th, 2018. Being that he left office, he has a gap in between. But it is still considered a renewal. And that prior order was for the global entity, not the coastal consulting, but for the same purposes. And that was granted.
Senator Ranker, do you have anything you wish to say at this point?
I'm very nervous that Fred is part of the Public Disclosure Commission.
What are they going to do?
But the one, in all seriousness, 2 points. One is both companies work globally and within the United States. It's just which ones the clients go to. And a clarification, it is Coast Consulting, not Coastal. So just Coast. As one word and not Coastal. And then I'm happy to answer any questions on these, but the one point I would make on the piece for Coast Consulting is that as a coach, as a licensed coach, I sign confidentiality agreements with most of my clients, not all, which is why some of them I'm able to disclose, and I will when I can. But it's a very strict agreement that I sign, and so I'm unable to share who the client is out of respect and appreciation for that relationship with the client, similar to a counselor. And so, and this is very normal within executive coaching.
Thank you. So I have a question on the threat to your safety that you cite in asking for the modification regarding the residence address. Can you tell us if that is a continuing threat, or if there is a protection order or something that we can look to? Our statute says we can relieve that particular burden only if there is a demonstrable safety consideration right that is current, and that for which there is some evidence of why the threat should be taken seriously, continuous.
So because this is a public meeting, I'd rather not get into the details. There were actually 3 threats over my time in the Senate. And the final one, we don't know if it's continuous or not. But I will say that I was told by my local sheriff and by ATF agents that I needed to change my behavior. And it really alarmed and frightened particularly my family. And so I have no idea if that threat is still real. I sure hope it's not. I pray that it's not. But when my wife and I were discussing running for the very small Charter Review Commission, which I didn't even know needed to file with the PDC, one of the things that came up was, the safety of my family. And so I don't have a way to prove to you that it's still continuing. And like I said, I don't know if it is. I can tell you that it was scary for a while, I'll tell you that.
Is this information available on public and other places publicly?
No. No, because it was never directly linked. Like I said, I'm torn on how much I want to say publicly about it. But it was not directly. They weren't sure if I was the target or not. I'll say that. But it was enough that there was a lot of law enforcement and others engaged, and like I said, I was told I needed to change my behavior. I was told I needed to look under my. I was told I needed to look under my car before I started it. I mean, it was difficult. And again, I don't know. I don't know if that threat continues, and I don't know if and it was not. No one was sure I was the target. Absolutely, but that was one of 3 different things that happened. One was very early in my career, a threat at my district office, and then another one was associated with threats toward me physically. But those were earlier on. It's this last one that makes me file this modification. And again, I'm happy to disclose, the town I live in, the value of the home, everything else. Just putting the specific home address is a concern.
And the alternative mentioned by Tabitha, it doesn't satisfy your desire for a little less transparency.
Maybe I'm not understanding. Tabitha, by the way, Tabitha's great. You guys should give her a raise. She's absolutely amazing and professional and kind and supportive. So thank you, Tabitha. Maybe I'm not understanding the second option there or something. Can you explain that to me, or can Tabitha?
Tabitha?
Yeah, so this is the option that we spoke about with the parcel number or legal description.
Yes.
Or
well,
the address.
Yeah, the parcel number is the same as an address. I mean, particularly, I don't know about the other 38 counties, but San Juan County on Polaris, which is a application and a program they use on their website, you can put in a parcel number and it comes up with, you know, my name, the street address, everything. So if you're saying list the parcel number instead of the street address, there's not really a difference there because of what's accessible very easily online.
So that goes to my question about is your address easily accessible online already?
People could probably pull up past PDC reports and other information. I can Google myself right now and see if it comes up easily. I imagine the answer to that is probably yes. The question that I would raise is, does listing it in more places make it better? or you know, I'd rather have at least less accessible. So maybe one less place where you can search for it.
We're not unsympathetic to privacy concerns and safety concerns. That we do operate within the statute, and the statute that gives us very, very circumscribed power to modify the requests that all F1 files have to file the information. Are there other?
I'm sorry.
Go ahead.
I was just going to say, I just Googled for my own home address, and it comes up as the P.O. box. So far, I haven't found it, but I'm sure with a more exhaustive search, I could.
Okay. Commissioners, would you like a separate to separate these issues from, or is there? You could handle it in one motion, I suppose. One up for one and down for one, or however you would like to do it. Bill, do you have a thought on how to process this?
Well, I mean, I don't have any problem with the aspect of it relating to Coast Consulting, but I haven't heard enough about the threat. You know, given the fact that it's well known that the address is Orcas Island, not just San Juan County. I don't think there's a basis for excluding the address or the parcel number at this point. So I do see them as separate questions.
Great. Well, would you start with a motion for one or the other pieces of the request, Bill?
Well, I would move that the request be granted as it relates to the client or customer of Coast Consulting, with that made retroactive if necessary. I believe that doing that does not undercut the purposes of the statute or frustrate the purposes of the statute. I believe that it would involve a manifestly unreasonable hardship to require the divulging of that client who wishes, expects, and is entitled to confidentiality.
Is there a second to the motion?
I second it. I do have one question. Would this be for just the campaign, or would this be for the term of office of elected?
So the term is actually just 1 year for the office that Mr. Ranker is running for. And so I'm guessing you could approve it for the candidacy and the term of the office, but I think we've been going with candidacy for candidates and making them reapply if they're elected.
Is that your pleasure, Bill?
Yeah, no, that's fine.
I'm fine.
As broad as possible. You get in there and clean up that charter and then get out, I guess, in one year.
All in favor of the motion to approve this modification as it relates to the business ownership will say aye.
Aye.
Aye. Opposed, no. And that motion is carried 5-0. And now as to the address confidentiality requested, is there a motion on that piece? Vice Chair?
I would move that the commission deny the partial reporting modification as requested on the basis that the applicant has failed to show that a literal interpretation of the law or application of the law would cause a manifestly unreasonable hardship, or that modification would not frustrate the purposes of the act.
Is there a second to that motion?
Second.
It's been moved and seconded that the partial modification for safety concerns as relates the address that motion be denied. And is there further discussion? Hearing none, all in favor of that motion will say aye.
Aye.
Opposed, no. And that motion will be denied on a 5-0 vote as well. So thank you, Senator Ranker, for checking in, and best to you in your efforts in San Juan County.
Thank you. Well, what do? I have to refile now and put the parcel number on or something? What?
Yes. You need to go ahead. Go ahead, Tabitha.
I'll get a hold of you, Kevin, and we'll go over your options again.
Thank you very much.
Thank you.
Everybody.
Thank you for your service. Okay, let's see. Let's go back to new requests from Kelly Wicker, Office of the Governor.
This is Tabitha Townsend again presenting.
Thank you. And she is not participating, so we will go on the materials that she submitted. So Tabitha, would you present?
Yes. This modification request is for Kelly Wicker. It's an annual report, and it is a new request. She is professional staff and is eligible for the 3-year modification, which would cover 2019 through 2021. This is a personal residence safety matter request. Kelly is requesting a partial reporting modification to exclude her residential address due to the safety concerns. She states that there have been multiple complaints and threats in her time at the Office of the Governor. She states that since COVID-19 restrictions, there has been multiple threats to her, the staff in the office, as well as the governor. She has agreed to recuse herself if a matter came before her involving a conflict of interest between personal interests and public duties. PDC staff has informed Ms. Wicker of the residential address reporting alternatives set forth in WAC 390-24-200. And Kelly Wicker's records would be exempt from public disclosure if the commission finds, in accordance with RCW 42-17A-120 and WAC 390-28-080, that disclosure of such information would present a personal risk to a reasonable person regarding this safety matter. And I'm available for questions.
Tabitha, does she present to us that that threats were made personally to her or to staff in general at the governor's office?
She did not have any direct threats to provide. That she is the chief of staff and
assistant chief of staff.
Chief of staff, and that her safety concern is the general threats to the staff.
Thank you. Are there questions or comments from the commission, or is there a motion?
So I guess I would start with a motion. And I would move that the commission grant the partial recording modification as requested on the basis that a literal application of the law would cause a manifestly unreasonable hardship on the applicant, and that a limited modification would not frustrate the purposes of the act. And I'd speak to that if there's a second.
Is there a second to the motion to grant the exemption? The motion dies for lack of a second. Is there another motion?
Well, I guess there's only one other option. I move that the modification request by Kelly Wicker be denied for lack of a showing of a manifestly unreasonable hardship, and the fact that granting would frustrate the purposes of the act.
It's been moved and seconded that the request, modification request for safety concern be denied for lack of showing of a personal threat. Further comments?
I guess I'm interested in hearing from Commissioner Jarrett, because it sounds like while we are very, I think and I guess all of us, I'm sure, are very sensitive and empathetic to these applicants. I'm not sure what the difference is between this application for exempting the personal address and the two that we just denied. So I'm curious to hear from Commissioner Jarrett what he thinks the differences are.
Well, the difference for me was that this is one where there is a very active group of folks who are out there around COVID and the mask and all of the stuff that's happening. And that seemed to me to be put this at a higher level. I agree it's a close call. I was struggling a lot with Senator Ranker as well. I think there's reason to have been supportive of that, but I will go with the wisdom of the commission.
Other comments? Hearing none, we will move to a vote on the request to deny this particular safety request for modification as it relates to residential address. All in favor of that motion will say aye.
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 Opposed, no.
Aye.
And was that an aye or a no?
It's a no.
That's the way they do it on Mercer Island, right?
Yeah. It's an affirmative no.
Thank you. You're always a positive person. Staff will note that the motion passes 4-1 with Fred Jarrett, our esteemed vice chair, voting no in a roundabout way. We have our final modification of the day, Douglas Shue, and that is going to be presented by Tabitha Blacksmith.
Yes, Commissioner, and it's Douglas Shea. And I do need to be sworn in.
What did I say?
Shue or something like that?
No, okay.
I'm not sure.
Who knows? And would you be sworn in?
Yes, please.
Do you swear or affirm that the testimony you will give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. And we're also deciding this on the materials that were submitted. So would you present this request?
Absolutely. So this is a renewal with change modification request for Douglas Shea. Mr. Shea is the prosecuting attorney in Chelan County, whose current term expires in December of 2022. Mr. Shea is requesting a renewal of a reporting modification that would exempt him from disclosing the business customers that paid $12,000 or more during 2019 to Confluence Health. Mr. Shea has also requested a retroactive modification to exempt him from disclosing governmental customers that paid $12,000 or more to Confluence Health in 2017, 18, and 19. Mr. Shea erroneously believed that the reporting modification granted by the Commission on April 2nd of 2018 and renewed on April 25th, 2019 covered governmental as well as business customers. For this reason, Mr. Shea has expanded his reporting modification to request to include governmental customers that paid $12,000 or more to Confluence Health for reporting years 2017 through 2019. Confluence Health is a regional and integrated healthcare provider headquartered in Wenatchee. Mr. Shea stated that Confluence Health had a gross revenue in excess of $1.4 billion in 2018. According to Confluence Health's 2018 annual report and website, it operates 2 hospitals, 13 clinics in 12 cities, and has over 4,000 employees. In 2018, Confluence Health reported over 1 million outpatient customers. Mr. Shea stated that listing the governmental agency and business customer payments and real estate owned by Confluence Health would take an unreasonable amount of time for him and Confluence Health staff, thereby creating a manifestly unreasonable hardship. Mr. Shea is a board member of Confluence Health with no ownership interest. In his previous request, he stated he does not make decisions regarding daily operations. Mr. Shea stated previously that Confluence Health does not currently have software capable of sorting its customer list or sources of compensation and would require weeks to compile such a list utilizing multiple data systems and cross-checking. Mr. Shea did disclose payments made to Confluence Health by the jurisdiction of Chelan County in 2017, 18, and 2019 on his F1 reports. He did disclose governmental customers that paid $12,000 or more to Confluence Health in 2017, 18, and 19, of which he is aware and able to offer information. Mr. Shea has agreed to recuse himself if a matter comes before him involving a conflict of interest between Confluence Health and Chelan County, and has reviewed his initial reporting modification and certified there are no changes to the facts related to his request regarding reportable business customers. And I'm available for questions.
So what retroactive is he asking for then if he has already reported governmental customers for 2017, 18, and 19?
He reported the ones of which he was aware and was able to obtain information. He's not able to obtain information on the million other customers that they have. They're not able to provide that information to him. And so what happened in prior years, he had a modification for business customers. He thought that also covered some of the governmental customers, but it didn't. So I had to have him go back and amend his F1 reports and give us all the information he did have. And then, of course, he did report the jurisdictions payments with Confluence Health. So I had to get him up to speed. And so that's the part that's retroactive, is including some governmental customers.
Thank you.
Yes.
Are there questions by commissioners? Hearing none, is there a motion?
I would move that the commission grant the partial reporting modification as requested on the basis that literal application of the law would cause a manifestly unreasonable hardship on the applicant, and that the limited modification would not frustrate the purposes of the act.
I'll second the motion.
It's been moved and seconded that the modification be granted as requested. Are there further comments?
I'm going to vote against this because I believe that while it might be a hardship, I don't know that it's manifestly unreasonable. And I do believe it actually would frustrate the purposes of the act. I think governmental contracts are exactly what the public wants to know about. And especially given as the position that this individual is in. So I'm going to vote against this.
As it relates to the office he holds in Chelan County, is there anything that's not being divulged in terms of government?
No, Commissioner. He did report everything, all the government payments between his jurisdiction of Chelan County and Confluence have all been reported. And he did also report Medicare, Medicaid, information for the other governmental payments, but that is the only information he could access. So it would just be customers other than Medicare, Medicaid, and Chelan County.
Thank you.
Thank you.
Further questions or comments on the motion? Hearing nothing further, we will move to a vote on the request and the motion that you heard. All in favor will say aye.
Aye.
Aye. Opposed, no.
No.
And the motion passes 4-1 with Commissioner Lehman voting no. Thank you. That concludes our modifications for today. And appreciations to the staff, the great work that they do on preparing these for us. So we move now to item 8 on our agenda, enforcement updates. And Kurt Young, we have you in the hot seat.
Waiting for my picture to show up. Thank you, Mr. Chair, members of the commission. Kurt Young, compliance officer. This would be the compliance.
You're wearing a tie, Kurt Young. My gosh.
Yeah, the top button's not buttoned for the second portion of this, so somewhat informal. Thank you for that.
You're showing up. You're showing us up. Go ahead.
Good investigative skills there, by the way.
I don't miss a thing.
That's good. That keeps us all on our toes. So this reporting period covered from June 16th through July 14th. And as of the 14th, we had 44 active cases. 19 of those were under investigation and had initial hearings. 25 were under assessment. As of today, we do have 57 active cases. That includes 52 that were post-2938 and only 5 are pre-2938. So we're getting there on those pre-2938, but there are still a few stragglers out there.
Could you distinguish for my ancient brain the distinction between investigation and assessment?
Absolutely. The 19 that are under investigation, that means that they couldn't either be resolved within the 90 days or they were more complex and required more investigative work. And so we conducted an initial hearing with Peter presiding, and then those cases became under investigation. The 25 under assessment are all within the 90-day time frame and have not come to fruition of either a disposition or are requiring an initial hearing.
So it's investigated and then assessed and then adjudicated.
Correct. So the 19 under investigation still could be dismissed, but won't be able to be resolved either in the time frame for, complexity or responsiveness or whatever that might be. The other 25 under assessment, a portion of those may have initial hearings conducted, but we're trying to resolve as many of those within the 90-day period.
Thank you.
Sure. We closed 16 cases June 16th through July 14th. That include 2 cases that were closed with no evidence of violations, 5 cases closed with reminder letters, 1 case was closed with a formal written warning, 2 cases were closed administratively, 3 cases were closed with a statement of understanding, and 2 cases were returned as unfounded or frivolous. We have closed an additional 8 cases between July 15th through July 22nd, and one of those was a case that I had that was a pre-2938. We've opened 22 new cases since the 14th, so a little more than 9 days. So we are getting quite a few new cases. Of those 22, 8 included allegations of failing to file the F1 report. 7 included violations either by a candidate or a political committee of failing to file C3 and C4 reports as required, or to provide the expenditure details as required by the statute. And then the remaining are kind of a mixed bag of 2 of those I think were involving sponsor ID on political advertisement, whether that's the sponsorship or the party preference. There was one that alleged surplus funds usage, and a couple that were dealing with the candidate registration not being timely filed or complete. That's kind of it, unless the staff's still working to resolve as many cases as possible. The team's still on track and doing as good a job as we can with the remote working, and also the furlough days in July of kind of like other staff will be mentioning, has hindered our work a little bit, but we've soldiered on and doing as well as can be expected. So I'd be happy to take any questions or concerns.
I was interested in the Kennewick ballot case, Beck, from 2017, what that's about and why it resists putting to bed.
There was some, back and forth and some issues. It, is moving towards resolution now. We're working with the legal counsel on that. So that's probably our oldest case, and I know that the staff person working on that has that as a priority, and had just received some information in the last week that will guide, I hope, towards a resolution soon on that case.
I had a
Probably
question.
not the answer you're looking for, but.
Well, no, I figured it was a good explanation, but I wanted to hear it. I'm wondering if there are in your stack of cases that are being investigated or assessed or active, ones that for whom there is an election time sensitivity. I noticed, for instance, just to pick one at random, Joshua Freed, who is a candidate for governor. People are voting already in that election. There were complaints filed in February and March. Both are listed as assessment of facts. To the extent you can talk about that, and or whether there are any other ones that we're not getting ahead of the election cycle on.
Thank you. I can say that just on that case that there has been some staff progress in last week, and hopefully moving towards some type of resolution on that in the future.
I presume that to state what I presume is obvious, that we always try to get them out the door if there's a time sensitivity to a current election.
Absolutely, and we are cognizant of especially the ones with the current election cycle, and that is a priority in our triaging of those cases.
Thank you. I appreciate hearing that. Are there other questions from a commission or anything that you particularly noted as you look down these lists? Very good. I appreciate that. Was there anything further in the enforcement area that you wanted to bring to our attention?
Pardon?
Was there anything further?
No, I think that covers it. Thank you for your interest in this and keeping us on task here. The team is working diligently as always, and we do look forward to seeing the commissioners in person again. That would be a nice bonus.
Except I'll have to wear a tie then, maybe, huh? All right. Thank you so very much. Peter, I guess we're down to the final segment of the agenda, and so if you would take it wherever you would like to go, besides the mountains I see behind you.
Yes, I've made my way up Colonel Bob Peak in the southwestern corner of the Olympics while you all have been discussing.
Not even breaking a sweat.
Nice and cold up here, and I've been joined by a friend, so I apologize if it jumps in the way. So I think I could keep it brief. I've given you an overview of a lot of what's going on with the staff and our management of the agency despite COVID, and how well things continue to go in that regard. Which is not to say I'm not mindful of the pressures that staff are under for a number of reasons, including balancing work-life balance and those who have either family members that they take care of, or children, or roommates, or friends who are vulnerable to COVID-19, particularly susceptible to it, and the pressures of the uncertainties of school to come for family members. So I'm cognizant that everybody is juggling those pressures at the same time that they're figuring out how to get their work done. But so it's by no means just all a rosy scenario, but I'm very thankful every day that the staff is holding up so well and doing such a great job, and the management team is leading them through that so well. I did want to talk about our auditing pilot program. We have the authority, and not only authority, a mandate to perform audits under the Fair Campaign Practices Act, and we have met that mandate in recent years, dare I say decades, largely through our group enforcement efforts, which is no small task and is an important part of keeping filers honest and making sure that some of those most basic filings, C1s and F1s, candidate registrations and financial affairs, are filed timely and regularly. So we have that underway and continue to do that, but also it's been several years since we've had audits beyond that, certainly since we've had a formalized audit program beyond that. Going back to 2011, we did some auditing of lobbying registrations, lobbying forms for the public agencies, which continues to be an area of focus for me, to make sure that our sister agencies are doing what they need to do and meeting their mandates. And then in 2008, I believe it was, Kurt led the effort of auditing a select group of legislative races and some statewide races, not gubernatorial, but other statewide races, making sure we looked at competitive races and candidates of both parties, both on the legislative side and then the statewide elected side. So Kurt has been taking an important role in developing a program of audits going forward. BG also gets a great deal of credit for leading that. And Eric Agina, relatively new, although not so new these days, compliance officer, has been Kurt's right-hand person in that effort as well. And we're pleased to announce that we think we're close to being able to initiate a new program of audits. We are, again, trying to keep it focused and yet broad, in the sense that we want to make sure we capture campaigns from both of the major political parties, certainly, and a variety of races in consultation with Kurt and BG and Eric, as well as the compliance team broadly. We've come up with a pilot program where what we'd like to do is look at 2018 and 19 legislative and local races, both sides of the aisle again, where people are not involved. Those particular individuals, candidates, are not in 2020 elections. Not to say that we would certainly exclude current campaigns from an auditing program going forward, but as a kickoff way to do it, we would, at least at this initial stage, avoid the potential distraction to campaigns as they adjust to our new audit program, as we do as well. Also avoids any possibility that we're auditing one side of a competitive campaign and not the other, and the potential unfair advantages or disadvantages that could pose to one side or the other. So that's sort of the criteria that we started to look at. We want to make sure that they were competitive races where definitely active candidacies on both sides of the aisle, and that there were significant amounts of contributions, so that we're not looking at small campaigns or campaigns that didn't involve significant contributions or expenditures. And we'll be looking at things like, obviously, the key filings be the C3s and C4s, which are the reports of campaign activities, money coming in, money going out, loans, things like that. Make sure those things are timely for sure, and check the accuracy of those. As usual, our priority is on making sure the right information is reported and reported accurately and quickly and gets out to the public as such. Clearly, there could be a compliance aspect to this, depending on what we find. But we would anticipate doing that in a cooperative way with campaigns that I'm sure my experience has been that the vast majority of campaigns are looking to get it right. And when they don't, it's inadvertent, and would work with us to quickly rectify anything we find, and would look to use our relatively new tools the legislature has provided, such as remediable violations and minor violations, and work with the campaigns to use those tools where appropriate. But it's not to say that if something becomes contentious that it wouldn't lead to compliance that would come before the commission.
So do the auditees know they are being audited, and do you work with them, or are you working from the records that you have and seeing if they are in order?
They will know ultimately. We're looking to do is select, based on the outline of criteria that I'm articulating, that we would select races that made sense under those criteria and that represented various types of campaigns, and made sure that things were looked at from a competitive, both sides of the aisle type of perspective. And then we would start looking at the public reports, and obviously that's part of the selection criteria, would be the public reports before we would let any campaigns know that they are auditees, as you put it. But then we would anticipate working in a cooperative way with them. Obviously, they have to turn over records to us that complete the picture if we don't have a complete picture, and we have an obligation to safeguard those records as we perform an audit, and if we physically obtain any records that we, of course, remain the property of the campaigns and would be returned and safeguarded along the way. But ultimately,
would you think there would be an audit report published at the end of each of those cases, and would that be posted someplace?
Absolutely, for sure. We would produce audit reports in each of these cases. We anticipate some of those would be a nice, clean bill of health. I'm sure people would welcome that, and where things need to be corrected, we would identify that and identify the cooperation that we received in that case. And obviously, if anything were more egregious, that would be reported as well. That would be, of course, provided to the commission, would be provided to the public, to the campaigns themselves, and made public on our website. So all of those findings would be available publicly. And we hope to draw lessons from this, and that's part of why we're going somewhat broad with our selections, is that we hope to draw lessons about what we're getting wrong. So whether it's maybe our guidance is not specific enough, or we're not giving guidance in certain areas that finding campaigns are having trouble with, and take that into account. And then ultimately you could inform ideas for rulemaking or legislation that we would bring back to you all for consideration.
And training.
And training for sure, absolutely.
No, I really like the spirit you're launching this, of trying to help them be successful. It's part of our new tools that you mentioned, our new way of looking at not just being like the IRS auditor coming to get you. We're trying to help make sure you're successful and 100% compliant, and working with auditees to fill any gaps that they might have.
Absolutely, that's the spirit in which I look at it, and particularly as we're getting this underway, and it's something we haven't done in a while, and campaigns have not experienced in a while. We want to make sure we take it in that spirit.
Are there any questions or comments from the commission?
Just to second your comments, I think this is really a great opportunity for us. Thank you.
Well, thank you both for your comments and support. And again, I thank the team, Kurt and Eric and BG and Sean as well, and the entire compliance team for helping to develop this program, and look forward to implementing.
Is the first cluster, are you going to do those in some kind of order, like a list that you draw up and then work down the list, or are you going to do like five in a cluster, or how are you going to manage this?
Yeah, some of that's going to be dependent on resources. We've gotten ourselves through the what we hope is the most intense period of furloughs for the time being, and we're going from weekly 1 day a week furloughs to 1 day a month. 1 day a week, I think, impacted us I would say more than I anticipated, because we also had to be careful. We're in the furlough situation, not to get too far afield here, but we are all instantly converted to hourly employees in a furlough week. So rather than putting in the extra hours that I often do, I really couldn't do that. And when I might have, I know Kim is frequently guilty of, she and I might email after hours when something comes up. We really couldn't do that. So I couldn't go back, have dinner, and go back and check the computer and see what's happened. We had to be careful about that. We just had a meeting yesterday with our HR consultant from DES, and when we have non-furlough weeks, that's not a problem. So you'll be happy to know we can work plenty in those weeks when we're not having furloughs. It's only that 1 week a month when we will have one furlough day, when that becomes an issue. So I think that'll be a big change. I don't want to take advantage of that and ask people, okay, 50-hour weeks now because you've got a furlough day. So I want to be careful about that. But there are those budget uncertainties, and undoubtedly we'll get complaints arising out of the election itself. So we'll be balancing that with the ability to do this program. But BG, did you want to weigh in on?
I do. I just want to comment, I think, on what Peter just said, is just our priority will be to close cases. And so, we should have some capacity. I know things will get busier after the primary from past experience of Kurt and Phil, they tell us. And so, but I do anticipate that the team will have some opportunity to work on this. And then certainly after the election, we should be able to kind of go full bore on this.
And I don't anticipate, I may be proven wrong, but I don't anticipate that these are going to be, swarms of FBI agents, corralling records. I think a lot of this is going to be reviewing records on their face. And so I don't think they're going to be person-hour intensive. As I say, it may be proven wrong on that, and each step might lead to more steps. But I think it's something that will be manageable and we'll be able to move forward with.
Well, very good. This is a happy announcement.
Glad to hear it.
BG, did you have anything for?
Commissioner Lehman is dropped off and was trying to get back in, so he's not on right now.
I saw him try to get on about 7 minutes ago.
If he's unable to rejoin us, obviously I can connect with him separately if he has questions or anything else he's interested in the audit program.
BG, you were also on the agenda. What do you have for us today?
Yes, thank you, Commissioner Ammons. Just a couple things to update you on some other things that we're working on. One is I'm working on the continuity of operations plan, which is called a COOP plan, which is, to determine the essential functions and services of the agency. Oh, should a pandemic occur? Yeah, who knew? I think that we have been granted, we as in the state of Washington, agencies, boards, commissions, et cetera, a number of delays for because of COVID to push this out a little bit, but I think that it is due in the next couple months. So I'm going to have to be working on that somewhat in earnest along with the rest of the executive team. Also,
like the elections division has a wonderful COOP plan that's gotten some national plaudits.
Oh, cool.
And so they, they could shoot you over a copy of that just to see, if all the power goes out, if you have no computers, it's a whole range of things from minor disruptions to you can't come to the office anymore, like we're going through right now.
Right.
So it's good to have contingency plans and kind of a call down. What if somebody on staff were to test positive, and to use a current example, what's the phone tree for that look like? And just I'm a huge fan of COOP plans, and I think you'll have fun with it, I hope.
Yeah, ours is pretty outdated. I'm not exactly sure when it it's got a lot of that. It's got a lot of the, IT things, and we do have contingency plans for some of that, but certainly it does need some updating. And I will reach out to Lori and the Secretary of State's office and ask her for that. The other thing is Jana, Sean, and I are working on updating our internal policies to be sure that those are updated. We also have some team members that are working on the diversity, equity, and inclusion, some of the internal policies for that. And we have some deadlines coming up on those. So those are the some of the sort of behind the scenes work that we're doing, but yet they're all very important to the functioning of the agency.
Good. Well done.
Okay. That's
Any
it.
questions for BG? Kim Bradford, you're next up, and thank you, Kim, for doing a post on our action earlier today on City of Olympia.
Yes, thank you. Credit goes to Debbie on that.
Debbie,
she
good.
was had some quick work behind the scenes.
Thank you.
Thank you, Chair Ammons. Just a few updates for you. I did send yesterday a written report because it was so numbers heavy. I didn't want to have to reel those all off to you regarding our F1 review that's been underway for a couple years now. And the takeaway there is that we did review, 12 years of records and F1 records specifically for any potentially sensitive information, mainly account numbers. Prior to the launch of the F1 application the new F1 application in January, we often had filers submit to us attachments to their F1, and often those were unfortunately like brokerage statements that had account numbers on them, and so we knew that that was the case, and that in some cases potentially not all of the redactions had been caught because of the volume that we faced in paper forms back in the day. And so we did take another look at that, both with staff review and with a vendor. And I think the upshot there is that we found exempt information on less than 1/10 of 1% of those documents. But we did find some, and they have been redacted. And with that work complete, we were able to close out a longstanding request we had had for a number of years of F1s this week, in fact. So that is done. Filer assistance and customer service team has been working hard to try to balance furlough days and try to get the help out to candidates who need it, as well as political committees. July is a busy month for them. We have both the 21-day C4 that it was due last week, and we'll have a 7-day pre-election report due next week. We have inspection periods. We have just a number of deadlines and periods that we need to help filers navigate. They've been doing a great job at that, and have been able, despite the furloughs, to keep up at a pace that probably doesn't match our earlier pace when we were fully staffed, but what is much better than I had feared we might be able to deliver. So props to them for that. The other thing I'll mention is we continue, I've mentioned it previously at these meetings, we continue our website usability work. Our vendor has completed, I think it was about 15 testers that they took through their paces on finding things on the website. And we had an initial meeting with them to go over results. And they had some really good insights into what is working, what's not working. We were also able to test it with on accessibilities. A couple of people with screen readers were able to give us some feedback on potential hurdles they faced. So that'll all be wrapped up. Now we're looking at possible, as they finalize their recommendations, they'll be coming back to us potentially with some quick wins that we could do absent a full scale revise of the website, which has also been funded, but this would allow us to act on some of those recommendations more quickly. That's all I had prepared. If you have any questions, I'm happy to answer them.
Thank you. Appreciate very much the work of your team. James.
Thank you, Chair, and the rest of the commission. Kim always steals all my thunder because most of the work that we do is for her, but she only tells you about the good things. So she gets to convey all the good things. Without boring you, I think that it is important to say that the current furlough situation has been incredibly painful in terms of the impact that it's had on our ability to make forward progress, because the time remaining gets spent on just keeping things running. And so we are really looking forward to getting past the weekly furloughs, and the monthly furloughs, as Peter said, will be much more manageable. I don't know if the commission knows, but the entire IT staff is overtime exempt. and they do spend a lot of time working outside of regular hours, figuring out how to solve a particularly complex problem or coming up with new approaches, and not having that time available for them has really hurt their productivity. Other than that, operationally, things are going well for the agency. Really exciting news is that you all know that we had this ancient, old, horrible phone system, and you've probably seen it in the office. And because we were already planning to move our voice services to Teams, we were basically ready to go when the pandemic occurred and we temporarily moved things. But as of this month, we actually submitted a statement to the old phone vendor to discontinue all the services. We've actually transferred all of our numbers into the Teams environment natively, and have been pulling phones out of people's offices because they don't work anymore in the agency anyway. So the old desk phones don't even work. So it's really exciting. It was one of the most horrible and scary things actually when it came to the agency 5 years ago, was like, oh my God, you have your own phone system that you operate. So this has been a good thing. Kind of on the more downside news, I always want to keep you all well informed, and in our modernization effort, including replacing Orca, things have been going pretty slow. And over the last month, we've been really kind of plagued by dealing with issues of bad data and trying to verify that the migration is going the way it should. Has been a lot slower than we expected. The good thing in that is that we know that all of that's going on, and Kim and BG, as the product owners there, have been very involved in that discussion and aware, and we're looking for ways to adjust as we go, because the most important thing is that we're continue to get better as we go through this process. And I think one of the really exciting things that has come out of kind of examination of that, as well as the current process, is to try to get back to really working on the smallest possible pieces of work that we can fully deliver, and being more incremental in this than we have been would have helped us in where we are now, and is definitely the right way to go. So we're looking forward to coming up with some interesting ideas about how to be more incremental in that replacement of Orca, and ways of delivering better functionality to the filers. For example, reporting periods are kind of baked into that Orca program that people file with. And we've got a really interesting idea about making report submission something that you might do on the web. So you could log into the website and actually see when you have a report due based on filing periods and the status of your campaign, and actually doing that really early on without having to replace the whole Orca program to get there. So I am excited that we continue to be creative, and that we continue to be critical of our own processes. At the same time, of course, we'd like to do all that and then have everything be perfect at the same time, but that's not the reality of the world. So with that, I'll open it up for any questions that you might have.
Questions or comments? Well, satisfied customers here.
Great work, James. Great
Thank
work.
you.
Appreciated.
Thumbs up. Very good. Well, Peter or commissioners, is there anything for the good of the order? Hearing none.
Just finding myself not here on my end.
Yeah. I didn't hear what you
James
said.
wins for the best background picture.
Yeah, I wanted to be there. Well, the mountain was pretty gorgeous too.
Daybob Bay last Monday.
Yeah. Okay.
Really?
Ah,
Yeah.
There are upsides to furloughs.
There you go. The dog likes seeing you too.
Nothing further on my end.
All right.
I want to thank the commissioners for a job well done today. We're actually 15 minutes ahead of schedule, and so good heavy lifting and thoughtful decisions were made, and I appreciate it. And we will stand adjourned until next month. Thank you. Bye.
Thank you.